may I have my lord leave to mention one matter, my lord, within list. Serial number 25, my lord. Writ of delivery of possession has been issued by the executive. I pray that this case will be any time before I or tomorrow in final disposal. I have taken consent from the other side also.
First appeal, last appeal.
Second appeal.
What is the question of?
My lord, it is an admitted second appeal, my lord. There are two substantial questions of law fail. That whether in a summary proceeding where the relationship of landlord and tenant is not admitted, the defendant appellant can be evicted from his suit property. This is the first substantial question of law. And the second is whether the plaintiff have to file the suit for right title, interest and recovery of possession before the appropriate forum. These are the two substantial questions of law which have been framed on 27th of July 2021.
Comment one. एक बजे फाइल दिखाइए।
मतलब
एक बजे।
अदर साइड से
कंसेंट किए हैं ना?
हाँ वो कल के लिए बोल रहे थे, ट्यूसडे के लिए।
उनको बुला के लेके। मेंशन तो कंसेंट के साथ ही कर रहा हूँ।
जी जी। But he said ट्यूसडे will be.
उनके हिसाब से डेट नहीं होगा। आप मेंशन कर रहे हैं आज के लिए या कल के लिए?
Yes.
आज के लिए आपको अलाउ किया। बोलो लेके आइए।
Okay.
From heavy list, this case item 7, second appeal 1 of 1999.
In this case, means the substantial question of law has proved whether for the book.
आप बहस करिए।
Yes. No, see, this is a defendant second appeal against the judgment of affirmance. The plaintiff filed title suit weighing therein that defendant number 124,
टाइटल सूट का क्या नंबर?
title suit number 157 of 1991.
1981.
G. Weighing therein that the defendant number 124 be restrained from catching the fees and to grant of permanent injunction. The case of the plaintiff is Lordship Mechanics is substantial portion of law.
या प्लेन से पढ़िए। प्लेन से केस पढ़िए।
Plain से
केस पढ़िए।
judgment से ही पढ़ते हैं.
ठीक है, प्लेन से पढ़िए। What was the relief?
Relief is that the defendant number 124 be restrained from catching the fees and to grant of permanent injunction, Lordship. The issue framed by the learned trial court, Lordship, para level, Lordship.
प्लेंटिफ का केस पढ़िए। ट्रायल कोर्ट जजमेंट से पढ़ लीजिए।
The case of the plaintiff is as a para 2 से पढ़ते हैं. The case of the plaintiff is
ये
as a
आप एप्लेट कोर्ट जजमेंट से भी पढ़ सकते हैं।
नहीं इसमें पूरा डिटेल्स में आया है इसी के ट्रायल कोर्ट का पढ़ रहे हैं. अपीलेट कोर्ट में उतना डिटेल्स में नहीं आया है. para 2 से लॉर्डशिप परमिशन. The case of the plaintiff as stated in the plaintiff brief that he is the co-owner of the property as mentioned in schedule of the claim and he has got 2.85 share in the same. It is said that Mahesh Shah, the father of the plaintiff and defendant number 5, has held and possessed 5.45 share in the disputed time and been by virtue of the registered sale deed taken from the Janki Bhagat in the year 1942. It is said that Mahesh Bhagat has transferred the aforesaid 5.45 share in the disputed time and been referred above in favor of the plaintiff and defendant number 5 through a registered sale deed dated 14/7/1954. It is said that defendant and plaintiff and defendant number 5 were minors at the time of execution of the aforesaid sale deed. It is said that plaintiff and defendant number 5 came in peaceful possession over the aforesaid 5.45 share in the disputed time. It is said that on 7/1/1967 the plaintiff and defendant number 5 had given 2.85 share of the disputed time to Muhammad Suleiman defendant number 1 Thika settlement for a period of 12 years from 7/1/1967. It is said that period of Thika settlement has expired on 7/1/1979 and after expiry of the plaintiff came in possession over 2.8 pi share in the disputed time. It is said that plaintiff after expiry of the Thika period, defendant number 1 put Jira to the extent of his share in the disputed time. Since then, he is putting Jira.
So you are claiming 5.4 pi share.
Lots.
That is your total claim.
Yes. No, I am
डिफेंडेंट इज क्लेम
defendant claim.
जो अभी आप
What is the claim
रिस्पोंडेंट
of the
है
plaintiff?
प्लेंटिफ ओरिजिनल प्लेंटिफ का क्लेम
हाँ,
है
ओरिजिनल प्लेंटिफ का कितना है?
5 आना 4 share, 5 pi share,
5 आना and 4 pi.
4 pi share.
And the remaining is with whom?
Defendant number 1
1 to 4.
2.2 defendant number 1 2.8 pi ना 2.8 pi share लोग.
ठीक है. और डिफेंड नंबर 1 to 4 को रेस्ट्रेन करने बोला है.
जी.
सबका शेयर होगा?
सबका शेयर होगा. हम जो है 1976 में हम परचेज किए हैं गोपाल साहू से बाय वर्च्यू ऑफ रजिस्टर्ड सेल एंड द लंडन ट्रायल कोर्ट हेल्ड दैट इट इज ए मैन्युफैक्चरर.
नहीं. बात ये यू आर क्लेमिंग 5 आना 4 pi share.
नहीं प्लेंटिफ क्लेम.
Plaintiff is claiming.
Claiming.
Right? 5 आना 4 pi share.
4 pi share.
This 5 आना 4 pi share, did you purchase it from somebody?
महेश भगत.
Yes.
हम क्लैरिफाई कर दें तीन पार्टनर है तीन हिस्सेदार हैं जो बाल गोविंद भगत जुगल किशोर भगत जानकी भगत ये तीनों है 1/3 1/3 1/3 तीनों का हिस्सा है टैग. अब ये जानकी भगत से है जो वाइट रजिस्टर्ड सेल डीड डेटेड 24/8/42 दिस महेश भगत एंड गणेश भगत इसने परचेज किया जानकी भगत का शेयर जो कि 5 आना 4 पाई है प्रॉपर्टी में. उसके बाद है जो अब ये जो प्लेंटिव्स आर सन ऑफ महेश भगत इनका क्लेम है कि महेश भगत ने 1954 में वाइट और सेल डीड जो है इनके प्लेंटिव और इसके रिस्पोंडेंट नंबर 5 के फेवर में 5 आना 4 पाई दे दिया. सो दे आर सेइंग कि जब भी और ये जो डिफेंडेंट नंबर 1 या डिफेंडेंट नंबर 2 है जो इनका क्लेम यह है कि दे आर लीज होल्डर्स ऑफ बालगोविंद भगत एंड जुगल किशोर भगत. इनका लीज होल्डर है एंड देयरफॉर दे हैव राइट टू कैच द फिश इन द सेट पॉन्ड.
They have an existing lease.
No, now right now that lease is not existing. Now बालगोविंद भगत जुगल किशोर भगत आर इन पोजीशन. सो हम लोग का क्लेम ये था कि जब आप मछली मारने
जब अपीलाइन से बात कर रहे हैं ना तो आप बीच में मत.
अच्छा ठीक है हम
है ना. प्लीज डोंट डिस्टर्ब. या आप लोग का कॉन्फ्लिक्टिंग क्लेम इस तरह से नहीं डिसाइड हो सकता. लेट मी जस्ट सी व्हाट इज द केस ऑफ द प्लेंटिफ. लेट हिम प्लेस हिज केस. My only hitch which I am finding is that is the property you are only claiming part of the property.
Yes,
Not the full of the
2.8 pi lawsuit and the defendant number 3 and now he is the appellant before this honorable court. And 2.85
Plaintiff was also claiming a portion of the property.
Yes.
5 आना 4 pi.
जी 4 pi.
Nothing more.
Nothing more lawsuit.
इसको पढ़िए आगे. Para number 3.
The further case of the plaintiff, the defendant number 2, Muhammad Ilyas is the son of defendant number 1, Muhammad Suleiman. It is said that defendant number 2 is the Thika holder over the 5 and 4 pi share in the disputed time relating to co-share of the village Kandar. It is said that defendant number 2 has got no right title interest every portion of the disputed time and paid. It is said that defendant number 3 is the nephew of the defendant number 1. Hence all the defendants being the collusion with each other have been trying to misappropriate the proceeds of the disputed time without giving any notice to the plaintiff. He said that they have been further trying to catch all the fishes out of the disputed time in the back of the plaintiff and they are denying the share of the plaintiff even at the expiry of the Thika period. It is said the plaintiff is an employee of the HEC Limited at Ranchi. He resides at Dhruva. It is said that after taking undue advantage of the absence of the plaintiff, defendant number 1 to 4 always have been trying to evade the legal rights, title, and interest of the plaintiff in order to misappropriate the proceeds of the disputed time. It
Who
is
is
said
defendant number 4? Defendant number 1 is Suleiman.
And defendant number 3 is the Kamrul Hoda.
Defendant number 2 is Ilyas. Defendant number 2 is the nephew of defendant number 1. Who is defendant number 1?
Defendant Muhammad Suleiman, Lord, sir. Defendant number 1 is Muhammad
He is
Suleiman.
a nephew.
Yes.
Who is defendant number 4?
Defendant number 4, Lord, sir. Defendant number 4 is the Bal Gobind.
Balgovind Bhagat.
Bal Gobind Bhagat, Lord, sir.
Why has he been made defendant?
Lord, sir, Bal Gobind Bhagat is the formal party, Lord, sir.
Formal party.
Formal party, Lord, sir. No relief was claimed against the Bal Gobind. There is a specific statement of the plaintiff, Lord, sir. The main contesting is the respondent, defendant number 1, 2, and 3, Lord, sir.
So defendant number 1, 2 and 3 by claiming some right by virtue of Thika.
No. In the year 1954, Lord, sir, Mahesh Bhagat transferred 5/4 pie share in favor of the plaintiff and defendant number 5 virtue of registered sale deed. And 7/1/1961, the plaintiff and defendant number 4 have given 2/8 share to the defendant on Thika. This is the case of the plaintiff, Lord, sir.
Na, Thika par. So defendant number 1, 2, 3 are basically the Thika holders. Correct? They are not as per the plaintiff. As per the plaintiff.
Yes. And the case of the defendant is that 29/6/1954, Lord, sir. Mahesh Sahu sold 5/4 share in favor of the defendant number 1 by virtue of registered sale deed dated 29/6/1954.
Defendant में मत पहुंचे, तारा plaintiff तक अभी.
ठीक, इसी को आगे बढ़ रहे हैं,
हाँ.
पारा 3 से पढ़ रहे हैं. The further case of the plaintiff, that defendant number 2, Muhammad Ilyas, is the son of defendant number 1, and Muhammad Suleiman is said that defendant number 2 is the Thika holder over 5/4 pie share in the disputed and relating to co-share of the village Kanda. It is said the defendant number 3 has got no right title interest over the portion of the disputed land and field. It is said that defendant number 3 is the nephew of the defendant number 1. Hence, all the defendant being in collusion with the other have been trying to misappropriate the proceeds of the disputed land without giving any notice to the plaintiff. He said that they have been further trying to catch out fishes out the disputed tank in the back of the plaintiff, and they are denying the share of the plaintiff even after the expiry of the Thika period. It is said that plaintiff is the employee of the HEC, Hatia, and he resides at Dhruva. It is said that after taking undue advantage of the absence of the plaintiff, defendant number 1 to 4 always have been trying to evade the legal rights, title, and interest of the plaintiff in order to misappropriate the proceeds of the disputed tank. It is said that due to dishonest and illegal action of the defendant number 1 to 4, there is apprehension of the irreparable loss and injury to the plaintiff. It is said that plaintiff had approached the Mukhya, Sarpanch, and other respectable person of the village for intervening in the matter and protect the interest of the plaintiff over the disputed land. It is said the plaintiff made them on 19/12/1980 and they have advised him to take shelter of the court. It is also case of the plaintiff that the defendant number 5, Ram Narayan, has filed title suit against the defendant number 1 and plaintiff of this suit with respect to 2/8 share in the disputed land, and second appeal is pending before the High Court. It is said that number of the second appeal.
What happened to the second appeal?
I have checked the status of it. There is no information.
The second appeal 109 of 1980. Status.
It is
There has been a title suit. Who
Yes.
won this title suit?
The title suit filed by the Ram Narayan Bhagat Lordship against the defendant number 1.
Who won it?
Who?
Who won the title suit?
Lordship, title suit was dismissed, Lordship. The file by the Ram Narayan Lordship. हम आगे आ रहे इसमें आया हुआ. It
1980.
It is said that the number of the second appeal number 10 of 1980, it said share of the plaintiff number 2, plaintiff number 1, 2/885 out of the disputed time is not a dispute in the pursuit appeal. It is said that defendant number 1 to 4 are bent upon cash the fees out of the disputed time which are immature. It is said that it will be seized wastage of the property of the defendant number 1 and 4 to 4 and succeeding in catching fees of the disputed time. It is said the plaintiff will suffer
I don't get one thing. कि ये कैसे हो रहा है? It is said that the share of plaintiff 2 आना 8 pi out of the disputed tank is not in dispute in their proceed appeal.
This is
The
the key.
plaintiff is claiming 5 आना 4 pi ना.
Lordship.
Then why is it?
But in the year 1954, Lordship, the Mahesh Bhagat sold the entire property to the this one defendant number 1, Lordship, and thereafter unilaterally cancelled sale deed, Lordship.
अच्छा चलिए पढ़िए आगे. पढ़िए.
It is said that the plaintiff will suffer a local loss in jury if the defendant number 1 to 4 are succeeding in catching of the fishes out of the disputed act. It is said that defendant number 1 to 4 are not paying any deed to the request of the plaintiff, means the being helpless of the plaintiff took shelter of the court and filed the Partition suit. It is said that cause of action for the suit arose on several dates when the
What was the
defendant,
case of the defendant? Para 5.
defendant number 1 to 5 have contested the suit after
1 to
5.
4.
1 to 4 have contested the suit after filing their separate written statement. Defendant number 1 has filed his separate written statement. Defendant number 2 have filed their joint written statement. Defendant number 3 has filed the separate written statement. The written statement has filed by the defendant number 1 are identical. The defendant number 1 to 4 in the written statement have inter alia pleaded suit as frame is legally not maintainable and plaintiff has no cause of action or right to sue. It is said that suit for grant of permanent against these defendant cannot be maintainable because there is no any consequential relief claimed by the plaintiff in the suit. It is said the suit is also barred by the principle of estoppel, waiver, acquiescence and res judicata. It is suit is also barred under section 34 of the special relief because the plaintiff is out of possession of the suit property. It is said that plaintiff did not seek relief for declaration of his title over 208 pi share in the disputed time and paid his the Partition suit is barred and the provision is laid down in the special relief case. It is further case of the defendant 1 to 4 that it is true that Ganesh Bhagat have purchased 5/4 pi share in the disputed time and paid from the Janki Bhagat through the registered sale dated 24/8/1942 and they came in possession over same. It is said that Mahesh Sahu has said that they posted 5/4 share in favor of defendant number 1 through the registered sale dated 29/6/1954. It is said that defendant number came in possession of the aforesaid 5/4 pi share in the disputed time. It is said that Mahesh Bhagat, with his bad motive and malafide intention, after being influenced by the Etwari, the mother of the plaintiff and defendant number 5, has cancelled the sale deed 29/6/1952 through a registered deed of cancellation. He executed a fresh sale deed on 15/7/1954 in favor of Lakshmi Narayan Bhagat and Ram Narayan Bhagat with respect to 5/4 pi share out of disputed time and pin. It is said that defendant number has filed a criminal case under section 420 IPC against the Mahesh Sahu in which the
So the
Mahesh
deed on the basis of which the plaintiff is claiming, the defendant says that was cancelled.
unilaterally cancelled by the registered deed of cancellation which is not permissible by law also.
Continue.
Yes, it is said that on the basis of the compromise arrived in the title suit, defendant number 1 gave up his 2/8 pi interest in favor of the Mahesh Sahu and retained with only 2/8 pi share in the disputed time. It is said that in order to meet the family expenses, plaintiff Lakshmi Narayan Bhagat and his mother Musmat Etwari as a natural guardian of the minor Ram Narayan Bhagat, defendant number 5 executed a registered deed of lease 7/1/1964 12 years in favor of the defendant number 1 for Suleiman in respect to 2/5 years share in disputed as such said defendant came in possession over the entire 5/4 pi share in the dispute. It is said that 1973 defendant number 3 Muhammad Kamrul Hoda has purchased 2/8 pi share in the disputed time from Ravi Nandan Bhagat and Raghu Nandan Bhagat son of Ganesh Sahu. He began to disturb the defendant number 1 over the disputed time. It is said that defendant number 5 Ram Narayan Bhagat has filed a title suit number 31 of 1970 against the defendant number 1 and Lakshmi Narayan and plaintiff Lakshmi Narayan Bhagat in the court of Munshi, but his claim was rejected and part decree over 4 pi share was given him
There is
by
lot of dispute on title. Yes, there is lot of dispute on title. Many things are required to be adjudicated in the titles.
Therefore, my learned what has happened in this case, madam?
I heard him on the last day. In case there is a serious dispute on title, then under such circumstances, a
If there is serious
there is serious dispute. There is a cancellation of sale deed or of the sale deed, which on the basis of which you claim to be the owner of the property.
This is not the Fact is
Just
this.
a moment. This deed, sale deed dated through a registered cancellation, 14/7/1954.
That is-
Has it been exhibited?
Yes, that has been exhibited.
So is it in dispute that there was a cancellation deed?
No.
So, and you are claiming on the basis of this deed?
What has happened? थोड़ा सा खाली हम बता दे रहे हैं.
एक दो लाइन हुजूर आप बता रहे थे रिलेवेंट है, एक मिनट और हम देन उसको शेयर करेंगे. लॉर्डशिप मे कैन यू सी पेज 27 लॉर्डशिप
Of the?
of that Granite trial court lordship, page 27, para 23. बहुत इम्पोर्टेंट है, दो लाइन के बाद हम बोलना चाहते हैं.
Yes.
एक यहाँ बीच से हम पढ़ रहे हैं लॉर्डशिप दिखा है ऑन पेरिजल ऑफ द रिसाइटल, एकदम बीच में हुजूर एग्जिबिट H1 के नीचे में एग्जिबिट 1 इज द सर्टिफाइड कॉपी ऑफ द सेल डीड लॉर्डशिप.
Page 27.
जी
Exhibit
H.
D1/2.
उसके नीचे में
Exhibit
हाँ
H-1
उसी का 3 लाइन के बाद देखा जाए ऑन पेरिजल ऑफ द रिसाइटल.
on perusal.
Yes, on perusal of the recital of the sale deed, it is found that Mahesh Sahu has purchased 5/4 share in the disputed time from the Janki Prasad Bhagat through the registered sale deed 24/8/1942. Through the name of the Ganesh Sahu was also written in the sale deed. This sale deed further proves that Mahesh Sahu was claiming the exclusive possession over the entire 5/4 share in the disputed time. It is also mentioned in this sale deed that on 20/7/53, Ganesh Sahu has written a memorandum of family arrangement in favor of his brother Mahesh Sahu, through which relinquished his right title interest in the disputed tank lot and some other point in favor of the Mahesh Sahu. Law is well settled that a deed of relinquishment it is required to be registered lordship. It is an unregistered document. In this regard, lordship relying the judgment lordship. Para 17 lordship.
This law is well settled.
Para 17 lordship. May I please?
We don't need a judgment.
That's all right. And lordship now lordship may kindly see page
You read
number
further.
page number 35 lordship.
Page number 28 पढ़िए ना, आधा sentence मत पढ़िए.
अच्छा पेज इसी को पढ़ रहे हैं, इसी को पूरा कंप्लीट कर लेते हैं.
हाँ.
The exhibit directly support the claim of the plaintiff that Ganesh Sahu has got no right title and interest in the disputed land since 27/1953. His son Ravinandan Bhagat and Raghunandan Bhagat have got no right to transfer 2/8 share in the disputed land in favor of the Kamrul Hoda, the defendant number 3, through the registered sale deed 19/3/1976. The exhibit 1/A is the certified copy of the title suit number 38/1975 passed by Shri Someshwar Nath Pathak, deed and additional sub-judge Ranchi. On perusal of the judgment, it is found that learned additional judge has dismissed the appeal of the Ram Narayan Bhagat and prosecution of defendant Suleiman, and he confirmed the judgment of decree passed by the learned Munshi in title suit number 31/1976. This judgment further goes to prove that Muhammad Suleiman, defendant number 1, is not the exclusive possession of 2/855 in the disputed and as claimed by the exhibit 1/1 in the certified copy of the decree passed in title appeal number 38/1978. Exhibit J51 certified copy of decree of title suit number 134/1935. Exhibit K1 is the certified copy of the order sheet of the execution case number 1956, and exhibit L1 is the certified copy of the decree entitled suit number 31/1986. These exhibits are admittedly parties, hence no much discussion are needed for the same in the present suit. In my opinion, defendant will got no benefit on the basis of the exhibit in the present suit. Now lordship may kindly see page number 46 lordship. Paragraph 35, page number 46. पेज नंबर 46 का लास्ट 5 लाइन नोट्स. इन माय ओपिनियन से लॉस पेज 46 द लर्नड ट्रायल कोर्ट एकदम नीचे से इन माय ओपिनियन. In my opinion, the plaintiff has totally proved his right title, interest, and possession 2/8 share in the disputed time. Hence, he is legally entitled to get a relief for grant of permanent injunctive. I reject the argument advanced by the learned lawyer of the defendant. Although lordship, No relief was claimed for declaration of right title interest which is against the Order 7 Rule 7 of the CPC Lordship.
हाँ बताइए क्या बोलना है
यहाँ पर राइट टाइटल जो है यहाँ पर भी बोले हैं कि उनका राइट टाइटल है बिकॉज इंजंक्शन इज ग्रांटेड ओनली व्हेन अ पर्सन प्रूव्स हिज क्लियर राइट टाइटल। अगर हम राइट टाइटल दिखाएंगे तभी हमको इंजंक्शन मिलेगा, अदरवाइज नहीं मिलेगा। सो देयर इज नो डिस्प्यूट दैट विदाउट डिटरमाइनिंग द राइट टाइटल वेदर डिक्लेरेशन वाज sought or not, the court before granting injunction has to see whether the person claiming injunction has got right or not. ना मतलब हम यहाँ से पहले इसमें हम डिसाइड किया हुआ फाइनली उसको हम पढ़ लेते हैं, फिर हम इसका लास्ट पेज देखा जाएगा जो रिलीफ ग्रांट था, रिलीफ ग्रांटेड बाय द कोर्ट। द डिफेंडेंट्स 1 to 4 are hereby restrained through a permanent injunction from catching fishes and exercising all the acts of ownership over the disputed tank bearing plot number so and so और pertaining to खाता नंबर इतना below 0 district Ranchi in absence and without due notice and consent of the plaintiff in writing. However, they shall put jira and catch fishes in the disputed tank according to their shares with due notice and consent of the plaintiff in writing. So this is the relief granted. Now, one fact of
according to
this.
their shares means what
I said
their shares have also been declared
it is not in dispute. It is not in dispute. Appellate court में आ गया है.
so I just wanted to know what is the claim of the plaintiff had the claim of 5 anna 4 pi share as per the plaintiff's case.
Plaintiff's case is that मैंने plaintiff's father.
What is the area or proportion or whatever is claimed of the plaintiff? Give me figures.
2 anna 8 pi.
That was the claim of the plaintiff.
That was the claim of
No.
the plaintiff.
No.
Yes.
No.
देख लीजिए.
अब देखिए plaintiff का केस क्या है? 5 anna 4 pi.
दोबारा बता रहे वो बोल रहा है वो यहाँ पढ़ दे रहा है. Plaintiff paragraph page 2 देखा जाएगा.
Page 2.
Plaintiff in brief is that he is co-owner of the properties as mentioned in schedule of the plaint and he has got 2 anna 8 pi share in the same.
Okay. You are only claiming 2 anna 8.
Only months. यहाँ केस क्या है कि 5 आना 8 पाई जो जमीन है जो मतलब शेयर है इन द टैग, ये कह रहे हैं कि 2 आना 8 पाई मेरा है, 2 आना 8 पाई मेरे भाई का है जो कि डिफेंडेंट नंबर 5 है इस सूट में. सो प्लेंटिफ इज ओनली कन्फाइनिंग टू हिज शेयर सो फार एज 2 आना 8 पाई इज कंसर्न. अब नौ वाला केस जो एडमिटेड पोजीशन है इसमें कि देयर आर 3 पोसेसर्स ऑफ द सेट टैग. They were Balgovind Bhagat having 1/3 share, Jugal Kishore Bhagat having 1/3 share, and Janki Bhagat having 1/3 share. This Balgovind Bhagat has not executed listed, therefore this defendant number 1 and 2 are there, and therefore Balgovind Bhagat was made party as respondent number 4 in the suit.
Balgovind Bhagat is respondent number
4.
And Jugal Kishore?
जुगल किशोर को पार्टी में, जुगल किशोर से कोई डिस्प्यूट नहीं तो उसको पार्टी.
क्यों 1/3 तो उनका भी था.
जुगल किशोर की पार्टी में
लेकिन 1/3 तो उनका भी था ना.
हाँ उनका है लेकिन उसमें कोई डिस्प्यूट नहीं था. जो सारा डिस्प्यूट जो क्रिएट कर रहे थे यही लोग कर रहे थे, देयरफॉर दे आर पार्टी.
और जानकी भगत पार्टी है.
हाँ नहीं जानकी भगत नहीं, बिकॉज जानकी भगत से हम परचेजर हैं. वी हैव परचेज वाइट रजिस्टर्ड सेल डीड डेटेड 24/8/1942.
Plaintiffs are purchaser from Janki Bhagat.
जानकी
1/3.
1/3 share. This purchase was made in the name of Mahesh Bhagat and Ganesh Bhagat. It is relevant because the defendant number 3 will come in picture only because of this Ganesh Bhagat.
This is in the year 1942.
This is in the year 1942.
So,
Now, my lord, there
कितना
are
खरीदे?
5 आना 8 by.
पाँच।
Entire share of Jalki Bhagat.
Anna 8 entire share of 90.
But plaintiffs have brought on record the documents, that is Jamindari rent receipt, as well as the rent receipt issued by the state of Bihar, which was issued in favor of Mahesh Bhagat. There was no Ganesh Bhagat. Now they have also brought on record Exhibit 5, which was deed of arrangement, family arrangement, which they are saying relinquishment deed. That was not a relinquishment deed. That is family arrangement, which is not required to be registered in my office of Mr. Now, this Mahesh Bhagat,
Family arrangement amongst
amongst 2 brothers, Ganesh Bhagat and Mahesh Bhagat.
this is exhibit.
Exhibit 5.
Exhibit 5 और इसमें ये इस प्रॉपर्टी के अलावा और भी प्रॉपर्टी है. Now, this plaintiff is the son of Mahesh Bhagat. There are two sons. Mahesh Bhagat transferred in 1954 this property in favor of his 2 sons. This plaintiff and respondent defendant number 5. 2 pi, 2 आना 8 pi, 2 आना 8 pi. Now, this plaintiff is saying because
Just a
this-
moment. So, the entire property purchased
Yes.
in the name of Mahesh Bhagat and Ganesh Bhagat in the year 1942
Yes.
stood allotted to Mahesh Bhagat in the family arrangement.
In the family.
Entire.
Yes.
And then he transferred 2 anna 8 pi to plaintiff
Yes.
and 2 anna 8 pi to defendant by registered deed.
By registered.
What is the date of the deed?
1954.
Date of the deed.
Date of deed.
19/7/1954.
19/7/1952.
14 साल एग्जीक्यूट हुआ.
मेरा तो 19
14 है कि 19?
मेरा तो 19
इसमें तो दिया हुआ है 14 साल. 14 ही मान लो.
ठीक.
ठीक है, दोनों को 14 साल को ट्रांसफर. इसमें कौन सा डीड कैंसिल हुआ?
उसके बाद हाँ, ये जो 2054 में जो हमको डेट किए प्रायर टू माई डीड, जो अभी ये पढ़ रहे थे डिफेंडेंट का एग्जिबिट, दैट वाज द डीड एक्सिक्यूटेड बाय महेश भगत इन फेवर ऑफ डिफेंडेंट नंबर 1. डिफेंडेंट नंबर 1 के फेवर में एक भगत उनके फेवर में एक डीड हुआ जो कि हजूर एग्जिबिट है. वो डीड हुआ और उसके द्वारा जो है ये सारा शेयर जो है ट्रांसफर हो गया डिफेंडेंट नंबर 1 को. Subsequently, the same was cancelled. Thereafter, my lord, what happened? This defendant number 1 filed a title suit on the basis which my learned friend is saying cancellation won't transfer anything. That title suit, my lord, decided in compromise.
सूट हुआ. सूट हुआ. टाइटल सूट नंबर
134 of 1955.
1955.
1955 also.
This ended into compromise.
And it is
What was the compromise?
compromise. Compromise.
What was the compromise?
Compromise. Why?
Compromise has not been executed.
that has
बहुत
compromise.
कॉम्प्लिकेटेड क्वेश्चन ऑफ टाइटल
खाली हम दो बात बता
नहीं नहीं आपको
खाली-
जो बोलना
अच्छा,
चाहिए
हाँ,
आप
जो हम-
सुनिए, आप लोग का फैक्ट सुनिए, बहुत कॉम्प्लिकेटेड
fact-
क्वेश्चन ऑफ टाइटल है
नहीं इसमें
क्या?
हम खाली जो फैक्ट आया है हम खाली अजूर ट्रायल कोर्ट को पढ़ देते हैं और 2-3 पारा अपलेट कोर्ट का फैक्ट ये है जो कि वेदर देयर वाज अ टाइटल सूट, वेदर देयर वाज अ सेल डीड इन फेवर ऑफ डिफेंडेंट नंबर, व्हाटएवर देयर वाज, बट सब्सिक्वेंट देयर टू ऑल एक्ट्स देयर इज अ जरपेसगी डीड बाय these two brothers in favor of defendant number 1 wherein it has been recital says कि 5 आना 8 पाई जो है हम उनको दे रहे हैं. So whatever has happened in between the parties prior to this Jarpeski deed, the defendant number 1 admits that this Mahesh Sahu was having 5 आना 4 पाई. वही हम पढ़ देते हैं जो खाली उतना सा. ये नहीं, ये सारा फैक्ट है जो हम भी कह रहे हैं कि ये पूरा डिस्प्यूट आ जाएगा इसमें. लेकिन जब इसने सबके बाद डिफेंडेंट नंबर 1 ये एडमिट कर लेता है तो फिर नथिंग रिमेंस.
क्या एडमिट करना
यही जरपेस्की डीड में जब आप हमसे ले लिए, मान लीजिए पहले खरीदे थे, फिर डिस्प्यूट था, फिर ट्रायल हुआ, टाइटल हुआ और
तब तो
फाइनली
इतना डिस्कशन का जरूरत ही क्या था?
हम
खाली
क्या-
कंसेंट पे ही हो जाता,
नहीं हम लोग
एडमिशन पे ही हो जाता,
अच्छा, हम
तो
पढ़
कुछ
लेते
बचा
हैं.
ही नहीं था ना.
हम खाली ट्रायल कोर्ट को थोड़ा सा हम पढ़ देते हैं.
बताइए इशू क्या
2-3 पारा
क्या
पढ़ेंगे जो अपडेट करके बस. पारा 20 पेज 17
अपील कोर्ट का
नहीं, पहले ट्रायल कोर्ट पढ़ रहे हैं.
रादर टाइटल का तो एक इशू भी नहीं बना,
टाइटल क्लेम ही नहीं किया किसी ने.
और रिटन स्टेटमेंट में हम डिस्प्यूट भी कर रहे हैं
टाइटल क्लेम
पोजीशन
नहीं किए थे,
हाँ.
टाइटल का इशू नहीं बना था, लेकिन टाइटल का डिक्लेरेशन है.
डिक्लेरेशन नहीं है, टाइटल को पाया गया मेरे फेवर में. दैट इज व्हाट आई एम. हम पारा 20 पढ़ रहे हैं.
ऑफ द एपेलेट कोर्ट
ये पहले ट्रायल कोर्ट से पढ़ रहे हैं. इसमें जहाँ पर एविडेंस पारा 20 पेज 17 मैटर्स, खाली इसमें ट्रायल कोर्ट का जो कंसिडरेशन है जो ओनली डॉक्यूमेंट्री पार्ट हम खाली पढ़ रहे हैं. First of all, I am going to discuss the documentary evidence as adduced by the parties in this suit.
पेज नंबर 17.
The plaintiff has adduced many documentary evidences in this case. First of all, I am going to discuss the document as filed by the plaintiff in this suit. PW1 proved Exhibit 1, which is the registered sale deed dated 14/7/1954 as executed. Executed by Mahesh Sahu in favor of plaintiff Lakshmi Narayan Bhagat and defendant number 5 Ram Narayan Bhagat with respect to 1 acre 34 decimal tank and field of total area 4 acres 10 decimals bearing plot number so and so decimals land out of 2 acres 74 decimals land bearing plot number 2291 pertaining to khata number 99 being the grand total of 2 acres 24 decimals land for consideration of 3,000. On perusal of this sale deed, it is found that Mahesh Bhagat was in exclusive possession of 2.24 acres land and built out of disputed plot number 2090 and 2091 of Khata number 99, and he transferred his total interest in favor of Lakshmi Narayan Bhagat and Ram Narayan Bhagat. This sale deed amply goes to prove that plaintiff Lakshmi Narayan Bhagat and defendant number 5 Ram Narayan Bhagat have got their right, title and interest over 5/4 pi share in the disputed tank and field, and they came in possession thereof on 14/7/1954, and they have been dealing with the said share according to their convenience. There is no ambiguity in this document upon which same can be discarded. This document fully proves the right, title and possession of the plaintiff over 2.8 pi share in the disputed tank and field. PW2 proved Exhibit 2, which is the signature of this witness on the sale deed Exhibit 1. The signature of Nageshwar Prasad is admitted on Exhibit 1, has no much discussion is needed. On this exhibit, PW2 has fully proved that the sale deed dated 14/7/1954 was executed by Mahesh Sahu in his presence in favor of Lakshmi Narayan Bhagat and Ram Narayan Bhagat. Exhibit 3 is the lease deed dated to 25/9/65, which has been proved by PW3. On perusal of this exhibit, it is
देखिए
found.
इतना डिस्कशन हम क्वेश्चन ऑफ लॉ को देखते हुए नहीं करेंगे. फर्स्ट अपील नहीं
अच्छा,
करेंगे.
खाली हम अपलेट कोड पढ़ देते हैं.
आप खाली फाइंडिंग पढ़ाइए.
हम खाली फाइंडिंग पढ़ा रहे हैं.
फाइंडिंग पढ़ाइए that it is an admitted fact that they have that you have the title. बात खत्म.
हम अपलेट कोड ही पढ़ रहे हैं.
Admitted fact दिखा दीजिए that you have the title फिर तो ये बेकार ही किया ये एक्सरसाइज पूरा ट्राई को. It was a futile exercise. If it is an admitted fact that you have the title, what else is remained to be decided?
हम इसको एप्लेट को छोटा दिया है.
Para 28.
हम पारा 10 से पढ़ रहे हैं. बहुत छोटा है.
पैरा 10 से क्या पढ़े? फाइंडिंग पढ़ी है ना.
फाइंडिंग ऑफ कोड.
फाइंडिंग पैरा 10 में फाइंडिंग नहीं होगा.
Para 28 में finding होगी.
तो लास्ट पारा होगा इसका.
नहीं और है सर आगे.
हम पढ़ देंगे. फिर मतलब किस डॉक्यूमेंट को पर क्या रिलाई करके कोड बना है उतना तो हम खाली पारा 10 से पढ़ेंगे. The plaintiff had adduced documentary as well as oral evidence to prove his case, mainly to prove that Mahesh saw.
ऐसे नहीं करिए भाई. प्लीज डोंट वेस्ट अ कोर्ट टाइम. आप फाइंडिंग पढ़ें.
फाइंडिंग पढ़ रहे हैं.
नहीं भाई, फाइंडिंग में तो डिस्कशन है. आई यू कम टू द फाइंडिंग. व्हाट इज द फाइंडिंग ऑफ द कोर्ट?
एप्लेट को सीधा.
According to us, let's say para 28 started the findings.
यही तो है.
पारा
The learned trial court has considered all the evidence to come to a finding.
26 से हम पढ़ रहे हैं. Document wise court has given the finding. On each document court has given the finding, and therefore I was reading from para 10.
इतना नहीं पढ़ सकते.
तो हम अभी पारा 26 से पढ़ लेते हैं. 3 पारा.
पढ़ लीजिए.
Besides the said documentary evidences, oral evidence were adduced by the parties which falsify the case of defendant and establish the case of the plaintiff. DW1 in para 8 last 2 lines para so plaintiff witness number 20. The learned trial court has fully discussed all the evidences in detail on considering the same in his detailed judgment and has decided issue number 4 in favor of the plaintiff, giving his finding that the plaintiff has got exclusive right, title and possession over 2 each by share over the disputed debt, and he is legally entitled to a decree for permanent injunction against the defendant number 1 to 4 as claimed by him. The learned court below has also decided other issues in favor of the plaintiff and has declared this. This is the finding by law based on consideration from emanating from para 10.
ठीक.
2008 का जो जजमेंट साइड की थी उसको पारा 21 का लास्ट डी से मेरा कहना है कि हम कवर्ड है. D. Where there are necessary pleading regarding title and appropriate issue relating to title on which parties laid evidence, if the matter involves is simple and straightforward, the court may decide upon the issue regarding title even in suit for injunction, but such cases are the exception to the normal rule. The question of title will not be decided in suit of injunction, but the person having clear title and possession suing for injunction should not be driven to the costlier and more vexatious or wrongfully makes a claim.
पैरा नंबर कौन सा पढ़ा है?
पारा 21 का डी लास्ट.
21 का डी बोल के तो इसमें कुछ है नहीं.
ये
आपका पैरा नंबर 21 का वॉल्यूम 13 एसएससी.
मैं 2008 का 4 एसएससी. डी.
आप कौन से जजमेंट रिलाई किए?
एक खाली एक लाइन और बताना चाह रहे हैं. पेज 41 ऑफ द लर्निंग ट्रायल कोड. पेज 41 लॉस. पेज 41. एकदम मिडिल में जो देखा जाए फ्रॉम द रविनंदन भगत एंड रघुनंदन भगत लॉर्ड एकदम मिडिल में है फ्रॉम द रविनंदन भगत and
admitted it is para 10 in his cross examination.
in para 10 of his cross examination this witness had admitted in clear word that Raghunan Bhagat never deliberately in possession over the disputed, and in para 11 of his cross he admitted that Ravinder Bhagat Raghunan have got no document of title possession to 8 share in the disputed. This witness also hopelessly failed to support his claim as asserted in the written statement. On the basis of the evidence as deduced by the DW examined on behalf of the it cannot be admitted that said document has purchased 218 share out of the disputed time and quit from the Ravinandan Bhagat. Raghunandan through a registered sale deed dated 19/3/1976 he came in possession over the purchase shares. In my opinion, sale deed dated 19/3/1976 as executed by the Raghunandan Bhagat in favor of the defendant number 3. This is the appellant before the court is the defendant number 3 who manufactured the point which is without consideration.
That was not to be numbered.
Yes, not challenged and no relief was claimed by the lordship and the Supreme Court said that none
आप judgment
जी.
which judgment are you relying upon?
earlier lordship has given the
हाँ बताइए ना citation.
2014 14 SSC page 502 relevant paragraph 13 and 17 lordship.
13 and 17.
Yes. And second judgment lordship 2021 13 SCC page
Yes.
13.
This is applicant. Para 20.
Yes.
Para
Para 15 and 20 lordship. Another judgment lordship.
एक ही चीज के लिए कितना जज
नहीं दूसरे पॉइंट पर दे रहे हैं तो व्हाट रिलीफ वाज क्लेम्ड बाय 99 AIR 1999 AIR 99 पेज 409 para 4 lordship
1991
lordship mark किए मैं para 4 में party cannot be granted relief which is not claimed lordship if the circumstances के as such granting such relief which result in the serious prejudice to the other party and depriving the valuable right under the statute lordship. And another judgment is lordship 2027 SSC page 366 non payment of consideration amount lordship.
इसकी ये किस लिए आपको
नहीं वहाँ बोले हैं कि विदाउट कंसिडरेशन पेज 41 में बोले हैं इट इज मैन्युफैक्चर्ड डॉक्यूमेंट एंड नॉन पेमेंट ऑफ कंसिडरेशन अमाउंट द सुप्रीम कोर्ट सेज दैट नॉन पेमेंट ऑफ कंसिडरेशन अमाउंट इज नॉट ए ग्राउंड फॉर कैंसिलेशन ऑफ सेल डीड para 15.3 lords. So next
ये
thing,
point नहीं we are not going to decide whether they could have done it or not. We have to just see whether there was any relief to that effect. When the court is giving a declaration that a particular document is a manufactured document, there is no declaration to that.
no declaration. This therefore are 99 citation of but that's all.
देखिए Second appeal number 1 of 1999. This appeal has been filed against the judgment dated 25/9/1998 within bracket decree signed on 31/10/1998 bracket close passed by learned second additional judicial commissioner Ranchi, who has dismissed the title appeal number 20 of 1984. The title suit was decided by judgment dated 16/1/1984 within bracket decree signed on 3/2/1984 passed by learned 4th additional sub-judge Ranchi in title suit number 157/49 of 1981/83. The suit was decreed on contest. The appeal was dismissed and the defendant number, all the defendants are appellants,
No, only defendant number 3, Kamrul Huda.
only defendant number 3 is the appellant before us.
Appellant is defendant number 3, Kamrul Huda.
Please say once.
I am the defendant number 3, appellant is the
Only
defendant.
the defendant number 3 is
Is
the
the
appellant.
appellant. Lord.
करेक्ट जिस ऑर्डर से जो सबसे क्वेश्चन ऑफ लॉ फ्रेम हुआ है उसमें अदर अपीलेंट्स have filed कि they should be arraigned as a party though they have not preferred appeal that was allowed by this court.
That's
इतना खाली हम बता दे रहे हैं.
That's right. The records of the case reveal that on 11/7/2000, IA number 390 of 2000 within bracket R was considered, wherein the parents are two respondents, that is respondent number 2A to 2B and respondent number 3 had prayed to transpose them to the category of appellants, and same was ultimately allowed. The suit was filed for grant of permanent injunction against defendant number 1 to 4, restraining them from catching fish and exercising all acts of ownership over the disputed tank. As mentioned in the schedule of the plaint, bearing RS plot number 2290 and 2291, pertaining to khata number 99 of village Ginju, Thakur, PS Burmu, district Ranchi, measuring area of 6.84 acres. In absence and without due notice and consent of the plaintiff in writing. The suit was decreed in the following terms. ट्रायल कोर्ट का जजमेंट में फर्स्ट पैराग्राफ में आपको रिलीफ मिलेगा और जो ऑपरेशन है, ऑपरेटिंग ऑर्डर जो है उसको कोट करना है. दैट इज एट पेज नंबर पैरा नंबर 42. The appeal was admitted for final hearing by the order dated 11/7/2000 on the following substantial questions of law. The learned counsel for the appellant by assailing the judgments has submitted that there was serious dispute of title in connection with the suit property, but the plaintiff did not seek any declaration of title Further, no issue was framed on the point of title of one or the other party. But the learned trial court, after elaborate discussions based on materials on record, based on materials placed on record, held that the plaintiff had
Right title interest with respect to the suit.
para number 15 has held in para number
The page 46, Lordship. In my opinion, the plaintiff has totally proved his right title
has
interest.
held in para number 35 that the plaintiff has totally proved his right title, interest and possession over 2 ana 8 pi share in the disputed tank, and hence he is entitled to get the relief of permanent injunction, and rejected the arguments advanced on behalf of defendant number 2 and 4. The learned counsel has also submitted that in para number 32, the learned trial court has also held that the sale deed dated 19/3/1976 as executed by Ravindran Bhagat and Raghunandan Bhagat in favor of defendant number 3 is a manufactured document which is without consideration, and as such the same never became operative. It has also been held that the said document has been manufactured by defendant number 1 in order to grab the share of the plaintiff out of the disputed tank, and further held that Komrul Hoda was defendant number
3.
Okay, and further held that defendant number 3 never came in possession over 2 ana 8 pi share on the basis of the sale deed dated 19/3/1976 as executed by Ravinandan and Raghunandan Bhagat in his favor. The learned counsel submits that no relief was sought for with regard to declaration of sale deed dated 19/3/1976 as manufactured document.
Which is against the order 7, rule 7 of the
He has
CPC.
submitted that such relief which has been granted by the trial court, declaring the title of the plaintiff with respect to the suit property and also declaring the sale deed of the defendants dated 19/3/1976 as manufactured document is beyond the relief sought for in the suit, and such relief could not have been granted in view of order 7,
Rule 7 of the
Rule
CPC.
7 of CPC. The learned counsel has also submitted that disputed question of title cannot be decided under in a suit seeking injunction. He has submitted that in view of the aforesaid facts and circumstances, the learned trial court was not justified in entering into intricate question of title between the parties, and therefore the substantial question of law number 1 be answered in favor of the applicant. The learned counsel has then referred to the judgment passed by Honorable Supreme Court reported in bracket 2014, bracket close 14, SCC 502, para 13 and 17.
रिलीफ वाला 1991 में हुई
हाँ एक सेकंड, इसका कोई जरूरत नहीं है 2014 का, नॉट रिक्वायर्ड, इसको हटा दीजिए, 14 का डाटा
1990
has referred to paragraph number, para number
Four.
1991 में है,
जी para 4
referred to judgment reported in bracket 1991 bracket close 1 SCC 441 paragraph 4 to submit that a party cannot be granted a relief which is not claimed. And if circumstances of the case are such that granting of such relief would result in serious prejudice to the interested party and deprive him of his valuable rights under the statute. The learned counsel has submitted that the valuable right of the defendant has been taken away by virtue of the judgment passed by the learned trial court, whereby his sale deed has been declared as manufactured document, and therefore the relief granted, therefore declaration of title and the relief granted was beyond the scope of the suit. He has also relied upon the judgment reported in bracket 2025-21-13 SCC 135, paragraph number 15 and 20, to submit that suit for mere injunction does not lie when the defendant has a genuine dispute with regard to title and when he raises cloud over the title of the plaintiff. In view of the fact that issue of title can be decided after full-fledged trial based on evidence which would be led by the parties in support of their rival claim. And in such circumstances, a bare suit for injunction is not made without seeking declaration of title. The learned counsel has submitted that this aspect of the matter has not been properly considered even by the learned first appellate court by confirming the judgment and decree passed by the learned trial court. He has submitted that in view of the aforesaid facts and circumstances, the suit for permanent injunction was not maintainable in absence of a declaration of title, and therefore the second substantial question of law is also fit to be answered in favor of the appellant and against the respondent. With respect to substantial question of law number 3, the learned counsel submits that in view of serious dispute in connection with title, the suit for declaration of permanent injunction could not have been decreed. And therefore, once the suit itself is found to be not maintainable, then the substantial question of law number 3 loses its relevance, and therefore the substantial question of law number 3 be also answered in favor of the appellant. That's all.
Yes.
The learned counsel appearing on behalf of the respondents has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2008, bracket notes 4 SCC 594, and has in particular referred to paragraph 21 thereof to submit that the entire position with respect to grant of suit for prohibitory injunction relating to immovable property has been summarized in as many as 4 categories. He has submitted that the present case falls under category number 20, category enumerated in paragraph 21 with bracket D. He has submitted that the plaintiffs had clear title and therefore he has submitted that there was necessary pleadings regarding the title and the parties had laid evidence on the point of title, and therefore the court could decide the issue regarding title even in a suit for injunction. He has submitted that when the plaintiff had clear title and possession and was suing for injunction, the suit was maintainable and he should not be driven to costlier and more cumbersome remedy of a suit for declaration of title and he submits that both the courts have scrutinized the material and have held that the plaintiff had title over the property and therefore the grant of injunction was not beyond the scope of the suit. The learned counsel submits that in view of the facts and circumstances of this case, the suit was maintainable and merely because the learned trial court has pronounced on the title, the same cannot be said to be not maintainable. It was only incidentally the court had entered into the point of title and given a finding. Right? After hearing the learned counsels appearing on behalf of the parties, this court finds that the suit was for permanent injunction and the relief and further relief claimed was that in absence and without due notice and consent of the plaintiff in writing, the defendants be restrained from catching fish and exercise all acts of ownership over the disputed tank. The plaintiff claimed to be the owner of the suit property. To the owner of the property is mentioned in the schedule and claimed that he had 2 anna 8 pi share in the same. The plaintiff claimed that late Mahesh Shah, the father of the plaintiff and defendant number 5, held and possessed 5 anna 4 pi share in the disputed tank by virtue of registered sale deed from Janki Bhagat in the year 1942, who had 1/3 share over the tank. It was their further case that Mahesh Bhagat had transferred his entire share in the disputed tank in favor of the plaintiff and defendant number 5 through a registered sale deed dated 14/7/1954. And that the plaintiff and the defendant number 5 were minor at the time of execution of the aforesaid sale deed. They were in peaceful possession of the 5 Anna 4 pi of the disputed tank. It was further stated that on 7/167, the plaintiff and defendant number 5 had given 2 Anna 8 pi share out of the disputed tank to defendant number 1 on Theka/settlement for a period of 12 years, which expired on 7/1/1967. And they from 7/1/1967, which expired on 7/1/1979, and thereafter the plaintiff came in possession of 2 Anna 8 pies as a share in the disputed tank and was enjoying the property. It was the further case that the defendant number 1, that the plaintiff, that the defendant number 2, who is the son of defendant number 1, that defendant number 2 is the son of defendant number 1, who was the Thika holder over 5 Anna 4 pi share of the disputed tank relating to the co-sharer, and that defendant number 3 had no right title and interest over the portion of the disputed tank. The defendant number 3 was the nephew of defendant number 1. It was his further case that the defendant number 3, in connivance with defendant number 1, was trying to misappropriate the entire proceeds of the tank. It was also asserted that a title suit was filed by defendant number 5 against the defendant number 1 with respect to his 2 Anna 8 pi share in the disputed tank, and a second appeal was filed, being second appeal number 109 of 1980. The defendant number 1 to 4 had filed separate written statements, and their specific case was the suit was not maintainable. And they also claimed, and in their written statement, it was their case that Mahesh Bhagat and Ganesh Bhagat had purchased 5 Anna 4 pi share in the disputed land tank from Janaki Bhagat through registered sale deed dated 24/8/1942. And Mahesh Sahu Bhagat same.
Same. Second appeal पे जहाँ तक
Mahesh-
जो dismiss हुआ है, judgment मिली है.
And the Mahesh Bhagat sold the aforesaid 5 Anna 4 pi share in favor of the defendant number 1 through registered sale deed dated 29/6/1954. It was their further case that Mahesh Bhagat, with bad motive and ill intention, after being influenced by the mother of the plaintiff and defendant number 5, had cancelled the sale deed dated 29/6/1954 through a registered deed of cancellation, and a fresh deed dated 14/7/1954 was executed in favor of Lakshmi Narayan Bhagat and Ram Narayan Bhagat with respect to his 5 Anna 4 pi share out of the disputed tank. A criminal case was also instituted where Sri Mahesh Bhagat was convicted but was acquitted by the appellate court. A title suit was also instituted, being title suit number 134 of 1955, which ended in a compromise, and it was stated that on the basis of compromise in title suit, defendant number 1 gave up his 2 Ana 8 by interest in favor of Mahesh Bhagat and retained with him only 2 Ana 8 by interest in the disputed tank. It was the further case that the plaintiff Lakshmi Narayan Bhagat and his mother, as natural guardian of Ram Narayan Bhagat, defendant number 5, had executed a registered deed of lease dated 7/1/1967 for 12 years in favor of defendant number 1 in respect of 2 Ana 8 by share in the disputed tank, and as such the defendant came in possession of the entire 5 Ana 4 by share in the disputed tank. It is also stated that on 19/3/1976, defendant number 3 had purchased 2 Ana 8 by share in the disputed tank from Raghunandan Bhagat and Raghunandan Bhagat, the sons of Ganesh Sahu, and another title suit being title suit number 31 of 1976 was filed against the defendant number 1. But the claim was rejected and a part decree over land 4 pi share, land 1 Ana and over 1 Ana and 4 pi share was given to him by the learned Munsif. The judgment was confirmed in the first appeal, and second appeal number 109 of 1980 was pending before the
Which was dismissed. This is the
High Court. The counsel for the appellant has produced a photocopy of the judgment passed in the aforesaid second appeal and has submitted that the second appeal was dismissed. The second appeal filed by Ram Narayan Bhagat against Muhammad Sulaiman was dismissed. It was the specific case of the defendant number 3 that the plaintiff had got no share in the disputed tank, and hence it cannot be admitted that plaintiff came in possession of 2 Ana 8 by share on 7/2/1979. Rather, defendant number 3 had purchased 2 Ana 8 by share from Ganesh Sahu from his sons Ravinder Bhagat and Ramanandan Bhagat through registered sale deed dated 19/3/1976 and came in possession. The learned trial court framed the following issues for consideration. The learned court, while deciding, admittedly, no issue was framed in connection with title of the property.
right title interest.
Right title interest with respect to the suit property. And admittedly, no relief was sought for in connection with right title interest over the suit property. However, the learned trial court considered all the materials placed on record and came to a finding in para
35, page 46.
para 23 na pehले.
Para 35 में बोले, in my opinion, the plaintiff has totally proved his right title interest and possession of 2 Ana 8 paise. Page 46 में देखा जाए.
Page number?
Page number 46 के नीचे में.
Page number 46. Just a minute. Page number 46. कौन सा running page बोल रहे हैं, internal page?
नहीं, internal page not से.
46.
And paragraph 35.
in page number 46, in paragraph number 35, as follows. इसको मार्क पोर्शन को कोट करना है, ठीक है? The learned trial court also recorded in para 32 that the sale deed dated 19/3/76 executed in favor of defendant number 3 was a manufactured document. ये है ना?
जी,
Page 41 में.
page 41.
The finding is quoted as under. अभी relevant portion खाली quote करना है. The learned trial court, after having held that the plaintiff had right title and interest over 2/8 pi share in the disputed time, and also after having been held that the sale deed dated 19/3/1976 was a manufactured document, ultimately granted injunction in favor of the plaintiff in the following in the terms as quoted above. The learned first appellate court also considered the materials and was of the view that the learned trial court view in para number
28.
in para number 28 in para number 27 and 28 as follows. Quote करना appellate court का judgment. This court finds that there was serious dispute in connection with right title and interest over the suit property, and both the parties were claiming right title and interest based on registered documents, and one of the registered documents executed in favor of defendant number 3 was declared to be a manufactured document, although no such relief was sought for in the claim, and that was also considered while deciding the title of the plaintiff over the suit property. Admittedly, no issue was framed by the learned trial court, or no point of determination was framed by the learned first appellate court so far as the title over the property is concerned. This court finds that in the Honorable Supreme Court, in the judgment reported in bracket 2008 bracket close 4 SCC 594 in paragraph 21 has summarized the provisions, the position with regard to suit for prohibitory injunction related to immovable property in the following manner. The paragraph is quoted as under. The Honorable Supreme Court has clearly held that a finding on title cannot be recorded in the suit for injunction unless there are necessary pleadings and appropriate issue regarding title. The Honorable Supreme Court has also observed that even where there are necessary pleadings and issues, if the matter involves complicated question of fact and law relating to title, the court will relegate the parties to remedy by way of comprehensive suit for declaration of title instead of deciding the issue in a suit for mere injunction. This court is of the view that the present case will fall under paragraph 21 within bracket C. So far as paragraph 21 within bracket D is concerned, the same is not attracted in view of the fact that the matter of title does not involve simple and straightforward question regarding title, and it is not a case where the plaintiff had a clear title over the suit property. The entire narration of the claim of the parties and the evidences placed on record reveal that there was complicated question of title involved in the case. In view of the aforesaid facts and circumstances, this court is of the considered view that considering the relief of injunction prayed for in the plaint, it was not open to the plaintiff, and for that matter the court, to examine the question of title, which was of a complicated nature. And in order to, this is also apparent from the fact that in order to come to a finding that the plaintiff has title over the property, the sale deed executed in favor of defendant number 3 was also declared to be a manufactured document, which was not the relief prayed for in the suit. The substantial further, accordingly, the substantial question of law number 1 is decided in favor of the appellant and against the respondents. So far as the second substantial question of law is concerned, having held that the suit included complicated question of title, this court is of the view that the suit seeking permanent injunction without seeking a declaration of title was not maintainable. The second substantial question of law is accordingly decided in favor of the appellant and against the respondents. So far as the third substantial question of law is concerned, the plaintiff had claimed only limited share in the property, that is 2 ana
8 pi.
2 ana 8 pi, and the injunction was also granted only with regard to 2 ana 8 pi. But having held that complicated question of title was involved in the case and the suit for simple injunction was not maintainable without seeking a relief of declaration of title, this court also finds that the trial court has not granted relief with respect to the balance of the property. That relief has not been granted. The relief has only been granted to the portion of the property which was claimed by the plaintiff. The third substantial question of law is since the trial court could not have granted relief of permanent injunction in absence of any claim for declaration of title, the third substantial question of law loses its relevance altogether, right? In view of the aforesaid findings, the second appeal is allowed. The judgments and decree passed by the learned first appellate court and the trial court are satisfied. इसका एक फोटोकॉपी दे देंगे
जी दे दे
बिल्कुल आपको सारा चीज 3 चीज में मिलेगा, दोनों इंटरव्यू जजमेंट में सब्सटेंशियली मार्क है, खोजने में टाइम मत वेस्ट करिएगा, हमसे पूछ लेंगे। दूसरा जो ऑर्डर है इनका जिसमें सब्सटेंशियल क्वेश्चन ऑफ लॉ बनना है, ये 3 चीज आपको
So date is for order second hall, 2nd April 185 of 1995.
who's for the appellant? Yes?
जो एक एप्लीकेशन फाइल किए हैं सब्स्टिट्यूशन के लिए और सब्स्टिट्यूटिंग द एयर्स ऑफ रेस्पोंडेंट नंबर 5, आपका लास्ट डेट का जो ऑर्डर है उसमें 4 और 5 के बारे में मेंशन है। 4 के बारे में ये एक शब्द नहीं बोले,
बहुत पहले मर चुका है।
अब हुजूर हम
तो कहाँ से हम देखें कि मर चुका है?
बहुत पहले मरा या क्या क्या हमको नहीं हुजूर, हम इस पर काउंटर एफिडेविट दे रहे हैं
नहीं नहीं
इनके एप्लीकेशन
फोर
का
कब मरे?
काउंटर।
कहाँ से बोल रहे हैं आपकी फोन मर गया? ये सप्लीमेंट
Yes, yes. 2001 कहाँ से बोल रहे हो?
कौन किए थे तो बताया
तो हम यही लिख दें ऑर्डर में? यस?
उनका
एफिडेविट में क्यों नहीं लिखे?
उसमें उस समय ये था बालिग नहीं था उसमें, नाबालिग था उसमें।
तो आपका ये जो ओरल सबमिशन है इसको हम लिख दें क्या इसमें? क्यों नहीं लिखे हैं आप?
एक चर्चा नहीं है उसके बारे में।
वो तो हम बोले उनका जो लीगल हेयर्स है उसके बारे में पता लगा कि हमको बताइए कि लीगल हेयर्स कौन है।
तो एफिडेविट में क्यों नहीं लिखे कि रिस्पोंडेंट नंबर 4 हैज एक्सपायर्ड इन 2001? Why have you not put it on affidavit? बताइए
उसको मेंशन नहीं किया।
क्यों नहीं किए हैं? ये 2 अप्रैल 1995 का आप ही के चलते पेंडिंग है।
हमारा काउंटर एफिडेविट इसमें रेडी है,
ये
फाइल करेंगे इसके बारे में।
परफॉर्मर रिस्पोंडेंट है 4 और 5 जो है परफॉर्मर रिस्पोंडेंट है और 4 जो है सो 2001 में बोला गया है कि डेट कर गया, लेकिन
प्रोफॉर्मा मतलब what is the meaning of proforma? No relief has been granted to them. Relief has been granted to them or not granted to them? Then the suit has abated. The appeal has abated completely.
Completely it has, in fact, to that extent, the order has also been recorded. That's all that and
Proforma respondent कौन थे? Defendant number थे
4 और 5।
4 and 5
defendant number 4 and 5 in the suit. Essay number 185 of 1995. The counsel for the appellant has submitted that interlocutory application being IA number 12317 of 2025 has been filed for substitution of pro forma respondent number 5, seeking condonation of delay in filing substitution and for setting aside abatement. There is delay of
इसमें डिले के बारे में इनका डेट जो है
6
दैट इज वेरी, वो भी डिफर कर रहा है। इनका डेट डिले देखा जाए इंटरलोकेटरी एप्लीकेशन के ऑर्डर 22.5 में जो लिखे हैं, इनका डिले जो है उसमें एक अलग पीरियड है और लिमिटेशन में अलग पीरियड है।
एक ही फाइल किए हैं ना,
दोनों अलग अलग डेट है।
delay of 3564 days.
दूसरे जगह ये अलग हो गए हैं।
कोई बात नहीं सर।
3564 डेज हो रहा है इसमें। इसके पैराग्राफ 10 में देखा जाए तो ऑर्डर 22.4 बारे में पैराग्राफ 10 में आया है। 3650 days।
ठीक है, इससे क्या फर्क पड़ता है?
फर्क पड़े ना पड़े,
आप अपना जवाब फाइल कर रहे हैं ना, उसमें
मैं जवाब तो कर
बताइए।
रहे हैं।
ठीक। He has submitted that although nothing has been stated about pro forma respondent number 4, but pro forma respondent number 4 has expired in the year 2001 as per the information received from
appellant.
the appellant.
Yes.
95 का इनका अपील है.
The learned counsel for the respondent has submitted that if the respondent number 4 has expired in the year 2001, then the appeal has abated.
वही नहीं. Respondent number जरा सा.
Further, he
Respondent
wants to
number
file a
2A,
reply
2B,
to.
2C भी मर चुका है.
Further, he wants to file a reply to the aforesaid interlocutory application.
इस बात को लिखा मैंने इसको kindly take note of this fact. हम जो हुजूर के सामने सबमिट कर रहे हैं कि रेस्पोंडेंट नंबर 2A, 2B and 2C जो सब्स्टिट्यूटेड heirs of person है वो मर चुके हैं सभी. They have all died. इसके
आप
बारे में
रेस्पोंडेंट की तरफ से अपील कर रहे होंगे ना,
हाँ
इनकी तरफ से भी
तो
अपील
हम
कर रहे हैं।
इंफॉर्मेशन देंगे.
हाँ, तो कब मरे हैं ये भी इंफॉर्मेशन
हाँ
दीजिए।
देते हैं इंफॉर्मेशन वो भी दे
The
रहे हैं.
learned counsel
वो
for the
लोग मर
respondent
गए
has
हैं तो
submitted that the date of death and the detail of legal heirs of respondent number 2A, 2B and 2C will be placed on record by filing appropriate petition. कर दीजिए आप। कब रखना बताइए, वो भी फाइल कर दीजिए और इसका रिप्लाई भी
इनको बहस करना है. हम एक जवाब
बहस क्या करेंगे, अभी तो रेडी नहीं है केस।
हाँ
अभी 2A, 2B, 2C कब मरे हैं, उनका लीगल ईयर्स क्या है, ऐसा बताइए। आपको जिसने इन्फॉर्म किया है उन्हीं से पूछिए।
ये लोग तो सब एक ही जगह रहते हैं. They are known of this
कोई
fact.
बात आपने सबमिशन किया है तो एफिडेविट आप फाइल करिए।
ठीक है. एफिडेविट तो पूरा रेडी है.
नहीं इसका 2A, 2B, 2C
2C हाँ उसमें इमेली है वाइफ ऑफ पर्सन और
हम ये
2
नहीं
सन्स.
पूछ रहे हैं, हमको डेट ऑफ डेथ,
हाँ दे देंगे.
लीगल ईयर्स एंड सक्सेसर्स फाइल करिए। कब रखते हैं बताइए, आप ही को रिप्लाई फाइल करना है, कब
हाँ,
रखते
2
हैं
सप्ताह में रख दिए.
At the request of the counsel for the respondents, pose this case on 23rd.
थर्ड को रखा गया.
The required affidavit should be filed
जी
by
24th को कर दिया जाएगा. 24th 23 के बदले में 24.
ये कोई बात नहीं, कर तो देंगे, कोई खास बात है।
नहीं खास बात होने का है. हमको है अंदेशा कुछ इसलिए बोल रहे हैं. एक तो सेफ साइड अभी कह देते हैं फिर बाद में कहेंगे तो आप ही को कष्ट देंगे.
ठीक है, 24th को कर देंगे। The reply should be filed by latest by 22nd. 22 तारीख तक आपका एफिडेविट आ जाना चाहिए।
वो रेडी है. हो गया कल ही परसों.
Item 2, 73 of 1997.
Appellant,
This IA number 12398 of 2025 has been filed for substituting the name of the owner and successor of appellant number 1. Who
respondent
died
number 1,
appellant number 1.
appellant number 1.
Who
When
died
did he
on,
die?
who died on 9/7/2025.
Any objection, respondent? देखिए आइए नंबर 12398 of 2025 in essay number 73 of 1997 with the bracket R. The learned counsel for the appellant has submitted that appellant number 1, namely Ramphil Tigga, has expired on 9/7/2025.
Yes.
The document issued by the Mukhya of the village has been placed on record. He submits that the names and name of legal heirs and successors of appellant number 1 has been mentioned in paragraph 4 of the interlocutory application. The Wakalatnama
Also filed.
has also been filed along with the interlocutory application. Counsel for the respondents has no serious objection with a prayer for substitution. After hearing the counsel for the parties, the prayer for substitution of the appellant number 1 is allowed. The counsel for the appellant is directed to delete the name of the appellant number 1 and insert the name of legal heirs and successors of appellant number 1 in the cause title in writing during the course of the day. चलिए हो गया सब्स्टिट्यूशन. अब क्या करना है बताइए ना, आगे कहानी सुनाइए. सेकेंड अपील है ना, सब्सटेंशियल क्वेश्चन ऑफ लॉ देखिए. इसमें टाइम का कोई काम ही नहीं. ये इतना पुराना केस है 97 का. सूट कब का है? 88 का, 81 का.
97.
हाँ
97.
97 का सूट नहीं है ना, सेकेंड अपील है 97. सूट कब का है?
97.
सूट 97 का नहीं है मैडम. सेकेंड अपील में भाई फाइल थोड़ा सा पढ़ के आया करिए, बेसिक चीजें. 42 of 1988. ठीक है, तो अब आप बस अब 2026 नहीं होना चाहिए ना इसका. बहस करिए.
सीनियर
कौन सीनियर? तो सीनियर को बुला के लेके आइए. उनको नहीं मालूम है कि सब्स्टिट्यूशन यहाँ पे 1 मिनट में अलाउ हो जाएगा? तो फिर वेरी सी कोई बात नहीं, उनको बुला के लेके आइए. ठीक है,
सब्सटेंशियल क्वेश्चन
हम देख लेंगे. बुला के लेके आइए.
मैं जा
आप हैं इसको?
मैं जा सकती हूँ.
हाँ आप जाइए, पास ओवर करने. बुला के लेके आइए.
Item 3, second appeal 283 of 2004.
हाँ बताइए.
Lordship, Mr. Prem Mani, Jharkhand on report. Lordship, I'm praying to withdraw this IR, Lordship.
आइए.
Yes, Lordship, with liberty to file fresh.
फाइल.
No provision has been mentioned, and this is pathetic, I hear, Lordship.
देखिए मेरा क्या लिखा है. पढ़िए पढ़िए. रीड इट.
This is drafted by my colleague, Lordship.
अब आप हैं तो आपको पढ़ना होगा ना. क्या लिखे हैं आपके साथ?
The present application has been filed for in place of substitution addition has been written.
किसका डेथ हो गया?
Respondent number 3.
क्या नाम है? क्या नाम है रिस्पॉन्ड नंबर 3 का? जोसेफ एक्का. नहीं दी डाई, वो भी नहीं लिखी.
कुछ नहीं लिखा हुआ है लॉर्डशिप. हमको अभी पास ओवर लेने के लिए बोला गया तो हम आइए देखें. कुछ नहीं लिखा हुआ है इसमें.
Being a respondent, Lordship, I filed one IA.
Yes,
Where I
they
have
have
mentioned
informed.
everything, Lordship.
इनका नाम लिखा हुआ है.
हाँ सब
Yes,
उसमें
Lordship.
लिखा हुआ है सब कुछ.
ये ऐसे ना आईआर विड्रॉ नहीं करके फाइल एप्रोप्रिएट पिटीशन प्रोविजन ऑफ लॉ इंसर्ट करते हुए उसका अमेंडमेंट करके फाइल करेंगे. जैसे विड्रॉ करके इसमें डेट ऑफ डेथ भी लिखा हुआ है.
Yes, Lordship. I have annexed the death certificate, Lordship.
कब का डेथ?
Lordship, this Joseph Eka died on 2009 and one Supriya Eka died on 2012.
ये लोग लेट से इन्फॉर्म किए.
So, Lordship, I have filed
पता नहीं था.
21.
21 में फाइल की.
And a detailed order has
उसके
been
बाद
passed
क्या?
by coordinate bench of this honorable
फिर
court.
क्या हुआ? ये तो सब्स्टिट्यूशन नहीं अलाउ होगा.
ये लॉर्डशिप डीएफडी हो गया तो उसके बाद रिस्टोर हुआ है. इसलिए लॉर्डशिप.
कब रिस्टोर हुआ? कब डीएफडी हुआ?
लॉर्डशिप.
तो टाइमलाइन तैयार करके आएगा क्योंकि इसको हम
बस
डिस्कस
वन आई एम सीकिंग ओनली 1 week टाइम टू अप्रोप्रिएट एप्लीकेशन फाइल.
IA number 6659 of 2024. The learned counsel for the appellant has submitted that the petition, that instead of filing a petition for substitution, a petition for addition of party has been filed. He submits that some error has crept up and accordingly he prays that he seeks permission to withdraw this IA with the liberty to file a fresh one. कोई objection है आपको इसमें?
Yes, Lordship.
क्या?
Lordship, neither setting aside of amendment has been filed nor limitation petition has also been filed.
Right? इसीलिए तो वो मांग रहे हैं लिबर्टी.
Lordship इसमें
And Lordship, one
Await
wrong
नहीं किया था.
affidavit has also been filed by them. I have supplied everything in my IA Lordship. In spite of that, they have filed one supplement, one affidavit Lordship, wherein they have stated that the Superior Joseph Eka died issueless. Although Lordship, I have supplied the legal heirs of Joseph Eka. And thereafter Lordship, this IA has been filed by correcting the same.
One, we will deal with everything. We will reply in that. Let them object to that IA Lordship. इसको बस छोड़ दिया जाए. उसमें ये ऑब्जेक्शन कर रहे हैं क्योंकि ये अबेट नहीं किया था. वो होना नहीं चाहिए था. DFT होना चाहिए. अबेट होना चाहिए था एविक्शन.
The learned counsel for the respondent has opposed the prayer. The matter is adjourned and is directed to be posted on next Monday. आपको जो करना है करिए. ठीक है. आप ये एफिडेविट कैसे फाइल करते हैं? He died issueless.
लेट्स हमको पता नहीं. लेट्स हम बस कर रहे हैं. वो कोड नंबर 16 में
Appearance.
Item 4 second appeal 336 of 2004 along with item 5.
Lordships, I am appearing in serial number 5, Your Lordships. In which 3 IAs are pending, Your Lordships?
Serial number 5 में था. What are the IAs that are pending?
Lordship, one is for substituting the legal heirs of appeal number 12.
IA number
IA number 7640 is for substitution.
7640 of
22, Your Lordships.
substitution of
Substitution of legal heirs of appeal number 12, Your Lordships.
applicant number 12. When did he die?
Your Lordships. He died on 31st August 2020. And
Where is the respondent?
on the last occasion, respondent has taken short password. Thereafter, this matter was not taken up.
This is section 5 of the limitation act,
Yes,
right?
Your Lordships. 8261 is for the limitation.
How much is the delay? 8261 limitation. How much is the delay?
Delay some days has been mentioned in the IA petition, Your Lordship, which was filed in the year 2022. But due to
As per our High Court rules, the
Yes,
exact date of delay is to be mentioned. Where is it mentioned? What else?
Your Lordship, and
These
for
are the two IA.
you said two more IA, Your Lordship. One IA is for setting aside the abated, the appeal number 12 was abated. And for setting aside that thing, Your Lordship.
With respect to appeal number 12.
12, Your Lordship.
And what else? There are all the three IAs with respect to appeal number 12.
Yes, Your Lordship. One is for limitation, and one is for substitution, and one is for abate. Setting aside the abatement, Your Lordship.
IA number 8260 of 2022 and second appeal number 108 of 2025. With IA number 8261 of 2022 and third IA number
7640.
and IA number 7640 of 2022. 7640 has been filed for substitution of applicant number 2. 8260 has been filed for setting aside abatement. And 8261 has been filed seeking condonation of delay in filing a substitution petition. The learned counsel for the appellant has submitted that the appellant number 12 died on 31/8/2020 and name of his legal heirs and successors have been mentioned in paragraph 1 of IA number 7640 of 2022. The वकालतनामा इतना सारा नाम है, इसमें एक ही नाम है और वकालतनामा इतने लोगों का फाइल किया है।
For other appellants, please acknowledge the Mirash's duty. Mr. Ashish Kumar is
इसमें तो इस तो औरों का दिए हैं, उसका लीगल ईयर का तो नहीं दिया। 12 तो काटा हुआ है, कासिम मियां काटा हुआ है।
Chirauddin Mia Kalashas. Chirauddin Mia is the legal heir.
देखिए सर,
Chirauddin Mia Kalashas name हमको भी दिख रहा है.
let notice be issued to the proposed legal heirs and successors of the appellant number 12, for which the requisites under ordinary process as well as speed post be filed within 15 days from today. In all, ये तीनों इंटेलेक्चुअल एप्लीकेशन close this case on 3rd of November, awaiting service report. In the meantime, it will be open to the respondents to file a reply to the individual application. Office to tax speed posting. अगर आपको इस बीच वकालतनामा मिल जाता है तो आप फाइल करें।
Notice to pending Russia and respondent number 12 has been added. Substitute appellant number 12 has been substituted in another serial of 4 elections. The legal heir of appellant number 12 has been substituted in serial of 4 elections. Already substituted.
तो नोटिस तो बिना किए कैसे करें?
ठीक है सर, हम कर
आप
देंगे।
उसमें अपीयर हुए हैं?
नहीं, उसमें हम नहीं appear है
तो कौन अपीयर हुए हैं?
Learned Counsel Arvind is appearing in that case.
इसमें और तो कोई आई है पेंडिंग नहीं?
नहीं, इसमें
उसमें भी नहीं?
नहीं, उसमें वो आई डिस्पोज हो गया, जो अब सब्स्टिट्यूट हो चुके हैं।
सारे आई है पेंडिंग है।
तो लॉर्डशिप नोटिस भी कर देंगे, वकालतनामा कर सकते हैं।
आपको वकालतनामा मिल सकता है?
Yes,
तो
लॉर्डशिप।
सिंपलिसिटी रिटर्न कर देते हैं। फिर क्यों नोटिस करेंगे?
ठीक है, लॉर्डशिप मिल जाएगा वकालतनामा।
अरे मिल जाएगा?
That clerk is in the contact with the
एक सेकंड रुक जाइए मैडम। यस प्लीज। आपके सिर्फ सिंपलिसिटी रिटर्न कर देते हैं फॉर नेक्स्ट मंडे। At the instance, ऐसे लिखिए, the 3 interlocutory applications are pending in relation to substitution of appellant number 12. The learned counsel for the appellant has submitted that she might waive wakalatnama on behalf of the proposed legal heir and successor of appellant number 12. At her request, the matter is directed to be posted on next Monday. ठीक है? Okay. कौन सा पास होगा? आपका कोई पास होगा ना? हाँ।
Also, case happening to second case 73 of 1997.
My secretary come tomorrow, assistant doctor, because substitution petition file के थे अपने डॉक्यूमेंट डाइट डॉक्टर।
लास्ट इंटेलिजेंस तो कई बार हो चुका है।
इसमें हम सर्टिफाइड कॉपी पहले ललित महाराज सर के से फाइल करते सर्टिफाइड कॉपी में निकलवा दी डॉक्यूमेंट एग्जिबिट जितने सारे हम इसमें बोल नहीं सब निकल कल पे इस पर फर्स्ट केस में कर देंगे।
कल कर दें? At with the consent of the learned, उसका आधा डिक्टेशन हो चुका है सब्स्टिट्यूशन। With the consent of the learned counsel for the parties, post this case to कल हम लोग का वो बैच केस आ रहा है क्या? परसों आ रहा है। ठीक।
For hearing item 6, second appeal 126 of 2003.
दो वीक का समय दिया गया रेस्पोंडेंट को डेथ के लिए।
कब?
कब
कब?
छूट गया।
हाँ? कब डेथ कर दिया? आपको कोई खबर किया होगा ना कि डेथ कर
पिछले ओकेजन में काउंसिल ऑफ द रेस्पोंडेंट है से
Who is dead? Respondent number? Who is dead?
परीक्षित मोदी।
Respondent number 6 के अगेंस्ट में तो अबेट हो गया।
6 का यहाँ 1 है।
6 का अगर अबेट हो गया है तो क्या सरवाइव कर रहा है इसमें? What was it? It was partition suit. It was partition suit. आइडिया नहीं है।
मेरिट पर उसको नहीं।
मेरिट में नहीं पूछ रहे हैं, पार्टीशन सूट है कि टाइटल सूट है कि क्या है तो बताएंगे आप, ये उसका भी आपको आइडिया नहीं है।
पार्टीशन सूट है।
कितना टाइम चाहिए? Direct type of chemical picture. Type of picture. Type of type of picture. The learned counsel for the appellant prays for adjournment. they have submitted that on the last occasion, it was reported that respondent number 1 has expired. The records of the case reveal that the plaintiff and the defendant number 5, 6 and 7 were found entitled to half share of the suit property in the partition suit. The defendant number 5, 6 and 7 were respectively Kripi Devi, Hilya Devi and Nirmala Devi. नाम ठीक से नोट कर लीजिए, KRIPI और Hilya HELIA and third है NIRNALA Devi. The appeal has already abated against respondent number 6, Hariya Devi, wife of Hariya Devi, who was pro forma defendant number 6 in the suit. The respondent number 1 was plaintiff number 1, who has also expired. Respondent number 1 was defendant number 1, plaintiff number 1 was defendant number 1, who has also expired. अब तो अबेटमेंट भी तैयार हो गया ये. Post on next Wednesday. Wednesday.
सब्स्टिट्यूशन
आप ही को डालना था ना, आपने कोई स्टेप नहीं.
2 weeks से ले लिया अभी हम.
At the request of the appellant, post this case on 22nd. Defendant, respondent number 1 का डेथ कब हुआ?
See, I don't have the knowledge of this. Arguing concern is code number 24. Maybe
सब्स्टिट्यूशन पिटीशन है इसमें डाल देंगे.
वो आप जानिए आप.
from day list for final disposal item 8, second appeal 293 of 2017.
Where is the appellant? Where is the appellant? So you argue this case.
It's just short puzzle, 1-2 cases.
The other cases might not be ready.
Perhaps not available.
Sorry,
He is perhaps not available today.
it's not available.
The council persons.
So,
Then we are ready to
we
argue.
decide it in his absence. He may not be there.
We will pass over on 1-2 cases.
First April 73 of 2018. Item 9 first April 43 of 2018.
Where is the appellant? Yes. Yes, argue your case. Time नहीं होगा.
Leadership one idea has been filed for substitution.
Of whose substitution?
One IA is pending for substitution. IA number 8367. Filed by applicant.
Any objection to I?
I do not have any objection because I have filed the petition under order 2210A, informing that 8 respondents died, and on that account they have filed.
I number 8367 of 2025 in FA number 43 of 2018. The learned counsel for the appellant submits that respondent number 4, 5, 7, 22, 32, 38, 45 and 49 have expired, and therefore the petition has been filed seeking their substitution. It has also been pointed out that prior to this, IA number 7836 of 25 was filed by the respondents under order 22.10A of CPC, bringing on record the factum of death and the details of legal heirs and successors. The learned counsel for the appellant has submitted that the matter relates to land acquisition proceedings. Land acquisition? Land acquisition?
Yes, ma'am.
Land acquisition
It
proceedings.
is land acquisition with regard to the requisitioning and acquisition of removal.
That's right.
Normal land acquisition directive is not.
That's right. Land acquisition proceedings. And he submits that substitution be allowed. The learned counsel for the respondents has no serious objections so far as the prayer for substitution is concerned. Considering the aforesaid facts and circumstances, and there being no objection from the side of the respondents so far as substitution is concerned, the IA number 8367 of 25 is hereby allowed. The counsel for the appellant is directed to delete the name of the respondent number 4, 5, 17, 22, 32, 38, 45 and 19 from the cause title and insert their names and success names, the legal heirs of the name of these respondents in writing during the course of it.
Hello, my one prayer. In their IA, the name mentioned of the legal heir, spelling mistake is there. Sometime when the award is there.
Spelling mistake.
In our petition, Charkumunda, at the same place, they have mentioned as Charku. Therefore, from my IA, the name may be included.
कौन सा पेज नंबर में बताइए? जयपुर में
पारा
कौन?
3 में है।
पैरा 3 का तीसरा लाइन तीसरा वर्ड
Para 3, Charku, thereafter para 5 में पार्वती होंगे. It all ought to be Parvato.
पार्वती तो ये मेरे में ठीक है पार्वती
तो क्या करना होगा?
Para 5 में पार्वती.
during course of the day
आप इनके पिटिशन से टैली करके करेंगे,
अभी
ठीक है? एक सेकंड, द लर्नड काउंसिल बता दीजिए भाई कौन कौन सा?
अभी हम कर
The learned counsel for the appellant has also submitted that there are certain typographical mistake in connection with spelling of the proposed legal heirs and successors. He submits that he may be permitted to make necessary correction so that it tallies with the spelling given in IA number 7836 of 2025. ठीक है? इसी के हिसाब से आप कर दीजिए साहब, राइट? आइए नंबर इन्हीं के आइए से आप कर दीजिए. He is permitted to carry out the necessary amendments in the cause title with respect to the legal heirs and successors of the aforesaid deceased respondents, whose details have been mentioned in IA number 733 है, यानी 7836 of
783.
इसी के हिसाब से आप कर दीजिए. कोई कंफ्यूजन नहीं है ना?
नहीं
ये आइए पहले डिस्पोजल है, कोई आइए पेंडिंग?
that was for
दो आइए,
information
वो आइए आइए सब
वो मेरा information वाला था.
दोनों उसको डिस्पोज ऑफ तो करना पड़ेगा ना? अब बताइए, अब क्या 2018 से चल रहा है?
हाँ अब इसमें ये ना कि मतलब LCR was called for, that has been received. I was saying only that that was a formal order but not official order. A copy of
इतना बड़ा LCR का कॉपी हम लोग कहाँ से स्कैन?
पेन ड्राइव में मिल जाएगा.
स्कैन हो गया है?
हाँ स्कैन हो गया.
है मेरे को पास?
हाँ
स्कैन नहीं है?
हाँ
तो अभी तक क्यों नहीं दिया?
नहीं हम
ऐसा एप्लीकेशन मत लगाइए.
हम नहीं लगाया इसलिए therefore I took a break.
Better take a break. हमारे ऑफिस पर एलिगेशन लगाने के पहले सोच लिया.
Therefore I didn't file order.
क्योंकि आप तो एलिगेशन लगाएंगे, हम शो कॉज कर देंगे.
नहीं it was not so.
बताइए. ठीक है, कब करना? सॉफ्ट कॉपी ले लीजिए, इससे पहले कि और लोग मरे, आप कर लीजिए.
My bad.
स्टेट पे आप ही ने ना सब सबमिट किया है रिकॉर्ड?
No state.
State है, state
not
अच्छा.
the deputy commissioner. This one over.
ठीक है, कब करना है बताइए. क्या इशू है इसमें?
My lord, that's
मेन
it.
डिस्प्यूट क्या है?
We are challenging the award along with the direction for payment of submission as also the interest. They have given a judgment, they are relying on a judgment. So we are distinguished that judgment. We
तो
have to.
यही तो कहानी है उस बैच में थोड़ा सा.
हाँ वो ज़्यादा पड़ा हुआ हमको लगता है इसको we can do.
हाँ तो परसों कर लेते हैं. आगे आपके पास रिकॉर्ड, आप रिकॉर्ड पढ़िए. 24 घंटे बहुत होते हैं.
नहीं तो फिर अब कुछ करने लायक नहीं रह जाता.
क्या करने लायक? आपको देखिए इनका तो इतना ही, आपका इतना ही है ना इंटरेस्ट इन सॉल्यूशन.
नहीं अगले वीक में किसी भी दिन 2 से रखते हैं एग्जाम.
2:15 में दूसरा बोर्ड.
अच्छा
बताइए.
एनी डे एट माय लॉट.
थर्सडे.
हाँ कल
थर्सडे.
बहुत कल
नहीं पोस्ट ऑन थर्सडे फॉर फाइनल डिस्कशन विद द कंसेंट ऑफ द पार्टीज.
कल नहीं किया जाए. मतलब अभी एकदम
कल का आज तो मंडे है,
हाँ
ट्यूसडे, वेडनेसडे, थर्सडे,
हाँ तब ठीक
थर्सडे को रखें
माइंड लो
in the supplementary courses.
तो ठीक है
Author mentioned case item 25, second appeal 202 of 2017.
Make the election. But in this case, defendant is the appellant before your auction.
Where is the respondent? Out of turn case कर रहे हैं, respondent का। आपने बोला था कि consent लेके मेंटेन करें। Consent लेके तो वकील साहब नहीं भाग जाएंगे। That is what
उनसे consent ले करके ही mention किया गया है, as I am informed. After my lord fixed this case at 1 o'clock, he has been informed about it. Although he said that he is not in a position to do this today, but it has been informed that it has been fixed at 1. This case arises out of an eviction suit.
चलिए, कोई बात नहीं, आपने उनको खबर कर दिया है ना?
उनको हम लोग
अब
खबर
बहस करें। उन्होंने कंसेंट दिया था, हम दिखाएंगे ऑर्डर में that you had mentioned this case with his consent. यही सबमिशन करके केस फिक्स हुआ है सुबह। I will record it that you have mentioned it with his consent. He has been informed, but he has not come. He is not appearing at this time.
He consented for Tuesday.
आप लोग आपस में बैठ के कंसेंट से डेट कर लेंगे तो क्या होगा?
He consented for tomorrow.
आप बहस करिए, आपका बहस सुन लेते, कल उनको सुन।
जी। This case was admitted on 29th of July 2021 by order number 9. Heard Mr. The instant second appeal has been preferred against the judgment dated 17/2/2017 and decree signed on 21/2/2017. Passed by the district judge.
ठीक है, आप इसको सब्सटेंशियल क्वेश्चन ऑफ लॉ पढ़िए ना।
नीचे में considering the same, let the instant second appeal. My friend has the instant second appeal be admitted on the following substantial questions. Whether in a summary proceeding, where the relationship of landlord tenant is not admitted, the defendant appellant can be evicted from a suit property. Number 2, whether the plaintiff have to file suit for right title, interest and recovery position before the appropriate forum. Call for lower court record notice be issued. The meantime status quo shall be maintained. Further is with regard to the liberty to the plaintiff to levy a suit for declaration of title and recovery of possession. May I?
Yes, yes, I agree with this. I'm hearing.
I take 1 minute. May I please the judgment of the trial court, my lord, starting from page 29.
There is a dispute of landlord-tenant relationship,
My lord.
and the plaintiff claims to be the landlord.
Yes, lord. What happened? He purchased the land from Mr. Shipujan Singh. Shipujan Singh had granted me permission to construct a thatched house over 2 decimal of land over plot number 983 and 2 decimal of land over plot number 986. They are the purchasers of plot number 986 only. The suit filed by them is only on the half portion of that thatched house, that is over plot number 986. But their sheet anchor is that I was inducted as a tenant in 1984. On 19/9/1984, a Kirayanama was executed. That is Exhibit 1. Over that, below, signature of the tenant is there. Father of the present defendant, named Mahabir Raza. And my lord, they say that this is the Kirayanama which proves that he is my tenant. And they used to receive rent at the rate of ₹60, and Hath Chitta was used to be given in consideration of receipt of that rent, my lord. Now, my lord, that is DW3, PW3, my lord, their witness has said it was signed by Parmila Devi, the plaintiff. But when we see Exhibit 1, there is no signature of Parmila Devi. My case is that it is a illegal and false document, ingenuine document. My father had never signed with any such Kirayanama because I was already there from before, about 70 years before, from the date of filing of the suit, and the then landlord, Sri Pujan Singh, I was washing clothes of his house and he had given me permission to construct a house. So, over 2 decimal of land over plot number 986 also. Apart from plot number 2 decimal of land over plot number 983. 983 is not in question. Now, look,
983 प्लॉट नंबर का तो जिक्र ही नहीं,
कोई जिक्र नहीं है, वो
986 and 985
85 उनका जमीन ही नहीं है। वो उन्होंने एक बीच में केस फाइल किया फॉर एनहांसमेंट ऑफ रेंट एंड दैट केस वाज ओवर प्लॉट नंबर 985. I said there also that I am not over 985.
Kirayanama is in connection with plot number.
1 minute. Exhibit 1. मैं महावीर
प्लॉट नंबर का ही बताइए ना, प्लॉट नंबर है उसमें?
हमको नहीं नजर आ रहा। नो प्लॉट नंबर, नो चौहद्दी, नथिंग। ये सिर्फ लिखते हैं कि मैं महावीर रजक, शॉर्ट में बोल रहे हैं, निवासी सरसेंसर छावलगांव मरार रांची, कहूँ मरार रांची स्थित मकान जो मिल घर के बगल में है, उसे श्रीमती प्रमीला देवी पति श्री राजेंद्र प्रसाद साहू से मुबलक 60 रुपया के दर से प्रति माह किराए पर लिया हूँ। मैं वादा करता हूँ कि हर माह अंतिम सप्ताह में निर्धारित रुपये का उपरोक्त घर मालकिन को चुकता कर दिया करूँगा। साथ ही साथ यह भी करार करता हूँ कि जब भी मालकिन हमें घर खाली करने को कहे, मैं सहृदय से बिना किसी हिचक के खाली करूँगा। इसलिए ये अपनी राजी खुशी से लिख दिया इस समय पर काम है। आज दिनांक 19/9/84 कोई प्लॉट नंबर नहीं, कोई
Is you are claiming title over the property?
No, I say vacant land was given by the then landlord, Mr. Sipujan Singh.
Who is Mr. C. Pujan Singh?
He is the vendor of the present plaintiff.
Vendor. And what is that salary?
Salary is of absolute salary.
With respect to, where is that? That has been exhibited?
Yes, yes.
Exhibit number?
Exhibit 3 series, I think. ये is 35 मार्केट में kindly find that is chart made. Plaintiff have filed certified copy of 3 CLD is 35. 3 CLD exhibit 3, 3 by A, 3 by and 3 by C. Description aforesaid 3 CLDs are exhibit 3 Santi Kumari Janak Prasad 2 356. Exhibit 3 by A. C. Pujan Singh. In chronology it is given. Janak Prasad is the Vendi 22/7/57, 8 decimal plot 986. So this is in contention.
Total 32 decimal.
G. And 3C is Galu Sao to Rajendra Prasad Sao. He is the husband of the plaintiff number 1. 22/1/57, 16 decimal plot 986 out of 32 decimal.
That's right. And what is the claim of your title? On what basis are you claiming?
I have not said that but I am claiming title. उन्होंने कहा my saying is that I am in permissive possession of Mr. C. Pujan Singh over a vacant land, and with his permission I had constructed the jhopdi and I was washing clothes in his house. May I take liberty to have some water below? So in sum and substance, and may I place the evidence of their witness.
पहले फाइंडिंग तो दिखाइए
जी.
अब एविडेंस का कोई स्कोप नहीं है,
नहीं.
ज्यादा स्कोप नहीं है, ठीक है? फाइंडिंग दिखाइए.
Yes, ma'am. Para 9 million.
Para 7 first. Discussion on the point of ownership.
Yes, landlord tenant
No,
relationship.
just tell me, is there any rent receipt which has been?
एक भी नहीं. Not one. They say up to November 1999, I have paid rent. They have to the plaintiff number 1, Parmila Devi. And she is a literate lady. She has been contesting suits many a time. There was a compromise also in some case. The suit was dismissed, filed by them regarding partition, and they filed an appeal, and in the appeal they compromised. Issue number 4 is with regard to landlord-tenant relationship. Firstly, I would like to take up issue number 4, which is core issue of this case suit. This issue is as follows: is the relationship of land and tenant, landlord ownership, between the plaintiff and the defendant. Pleadings of the parties on this issue. In this regard, case of the plaintiff is that they are owners and landlord of the suit premises, which is part and parcel of plot number 986. Pertaining to Khana number 17, the suit plot number 986, measuring 32 decimal, was purchased by Rajendra Saw, father of the plaintiff number 2 and husband of plaintiff number 1. Plaintiff number 1 has not deposed my lord. and not the husband has deposed. He is also alive, even today he is alive. Eh? Achha. Rather, so father of plaintiff number 2 and husband of plaintiff number 1 and his brother Janak Saw through various salaries and on the basis of a compromise decree passed in title appeal number 21 of 1998, the suit premises along with other properties were allotted to the share of the plaintiff. The further case of the plaintiff is that
टाइटल कहाँ डिसाइड किया है?
जी नहीं
There is a-
नहीं
नहीं किया है तो ये सब्सटेंशियल क्वेश्चन ऑफ लॉ कैसे बना है?
No, the Honorable Court was of the view that this requires a decision on the title of the plaintiff.
कोर्ट के व्यू से तो नहीं चलेंगे ना, चलेंगे फाइंडिंग्स।
पहला वाला तो है whether there is a relationship of landlord and tenant.
The first one is whether in a summary proceeding where the relationship of landlord and tenant is not admitted,
Yes.
the defendant applicant can be evicted from his suit property. In a summary proceeding, he can be evicted.
Yes, yes. My lord,
He can be evicted if
My lord. My lord,
otherwise the relationship of landlord and tenant is proved. If the kirayanama is
नहीं.
proved,
Yes, no,
it has been proved.
no,
No means
no Kiranama has been brought.
exhibit 1.
Exhibit Kiranama, my lord, PW3 says कि परमिला देवी ने साइन किया. And exhibit 1, the Kiranama shows that there is no signature of परमिला देवी.
कोई बात नहीं, साइन किया नहीं, वो तो सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है।
That gentleman is a witness to this Kiranama. He is a witness to this Kiranama, and he says कि हमको बुला के ले गई थी परमिला देवी.
There is a finding that you have been giving rent. There is a finding of the trial court that you have been given rent.
That is perverse.
वैसा तो सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है ना।
Well, then I humbly submit that my lord may.
नो ऐसा नहीं होता सब्सटेंशियल एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ इस तरह से फ्रेम नहीं होता। अभी सुप्रीम कोर्ट का जजमेंट आया, देखें कि नहीं?
My lord, in fact, for the interest of justice, Supreme Court has said that my lord will frame a issue.
नो, ऑटोमेटिकली हम नहीं फ्रेम करेंगे। I am not inclined to frame such an issue. There are two substantial questions of law framed.
Yes.
You confine yourself to the substantial question.
Lord, my sole case is that I am not his tenant. I was under permission of the landlord who sold the portion of the house and the land.
So you are not claiming title over the property,
Well,
isn't it?
My
Are you claiming title over the property? No,
no.
you are not claiming
No.
title.
I say he had given me, but I have not said that it was
So
a done.
applicants are claiming permissive possession.
Permissive
Not
possession.
not
What I
title.
have found. Yeah. I was given permission to construct a jhopri because I was a washerman of the house.
And not claiming title.
We have no people, man.
You were given land and you have constructed over the property.
Mine.
ये जो डिफेंडेंट का केस है ट्रायल कोर्ट के जजमेंट में जरा वो पढ़िए केस ऑफ डिफेंडेंट पैरा नंबर 3
My lord, obviously. Case of the defendant is at page 31, paragraph 3.
Yes.
The plaint as presented by plaintiff,
Next paragraph. According to the defendant.
according to the defendant, the suit as filed by the plaintiff is not maintainable in its present form, and that the suit is barred by law of limitation, acquiescence, and waiver, and no cause of action ever arose to file the suit premises. The real controversy between the plaintiff is in respect of title and possession of a suit land for which the plaintiff should have brought a regular title suit with prayer of recovery of possession by paying a bankrupt court fee on the subject matter in this suit. According to the defendant, the plaintiff has no right, title and interest in the suit premises as he has brought the suit on the basis of manufactured documents which with a view to grab the residential house of the defendant who is a poor Harijan. The defendant has denied relationship of landlord and tenant between the plaintiff and defendant or his father as stated and stated that plaintiff number 1 had neither inducted the father of the defendant in the suit premises as tenant at the monthly rental of ₹60, nor his father had executed any Kirayanama on 19/9/1984 in favor of the plaintiff number 1, nor paid rent to her. According to the defendants, the real fact is that the father of the defendant had constructed a Kacha proposed house over 2 decimal of land over plot number 986 and 983 with permission of Shiv Pujan Singh about 70 years ago.
Who is Shiv Pujan Singh?
He is the vendor of the plaintiff. Vendor of the plaintiff. Vendor in succession manner. One Shiv Pujan Singh about 70 years ago, who was the owner of the plot number 986, measuring an area of 16 decimals out of 32 decimals. The father of the defendant had used to wash clothes of the family of said Shiv Pujan Singh. According to the defendants, the judgment and decree passed in partition suit number 57 of 1993, this was dismissed. That partition suit was dismissed and an appeal was filed. In terms of compromise, is not binding upon the defendant as he was not party to the suit. And in fact, the suit was dismissed. A appeal was filed and they entered into a compromise.
Who were party to this suit?
The present plaintiff and their co-sharers.
The defendant was not party.
No, I was not a party. As he was not a party to the suit, and the said suit was collusive. 1. According to the plaintiff had no right to extend their residential house over Schedule A land, nor they have any personal necessity as alleged in the plaint. In fact, there are 4 Pakka houses having 40 rooms already. And I am over only 2 decimal of land in plot number 986. On the basis of our pleadings, the defendant have made prayer to dismiss the suit. As it appears from the record, next paragraph 4, as it appears from the record that during the pendency of the suit, the defendant was directed to pay rent to plaintiff under provision of section 15 of the Bihar Building Lease Rent and Eviction Control Act, white order dated 1/5/2010 passed by this court, but the defendant did not comply with the aforesaid order, as a result of which white order dated 29/11/2010, the defense of the defendant on the point of his eviction as tenant was directed to be struck on. My lord will find that it was over plot over 985, no, not 986. Issue for adjudication of the suit on the basis of the respective pleadings of the parties. In all 8 issues have been framed for proper adjudication of the suit, which are as follows. Is the suit maintainable? Have the plaintiff got valid cause of action, whether the suit is barred by law of limitation, waiver and acquiescence? Number 4 is important. is there relationship of landlord and tenant between the plaintiff and the defendant? 5. Whether the defendants are defaulted in making payment of rent. And 6. Whether the plaintiff have personal necessity of the suit premises bona fide for their own use and occupation. 7 is whether the personal necessity of the plaintiff can be satisfied by evicting defendant from part of the suit premises. 8. Whether the plaintiff is entitled to get the relief as sought.
Who is Mahabir Rajak?
Father, defendant's father.
Defendant's father.
Yes, ma'am. And it is alleged that Mahabir Rajak had entered into a kirana. He had signed over. The plaintiff gave as much as 7 witnesses. Plaintiff witness number 3, Laldhari Ram is the one of the signatory in the kirana. He says he was called by Parmila Devi, the plaintiff number 1, and she asked him to be a witness to it, and he signed over the kirana. He has said at paragraph 5 of the evidence that Parmila Devi had signed. My lord will find from exhibit 1 that there is no signature. Exhibit 1 doesn't bear signature of Parmila Devi.
Pramila Devi, that aspect has been taken care of by the courts.
I will place, it is a perverse fine. The order is in order to establish the respective cases of both the parties have produced evidence. The plaintiff has got in all 7 witnesses. Out of them, PW1 is Dileshwar Sahu, PW2 is Sikh Prasad, PW3 is Dalthari, PW4 is Hiralal Sahu, plaintiff. He is the son of plaintiff number 1. PW5 is Amarjit Kumar Rana, PW6 is Nikhil Goswami, and PW7 is Nand Kishore Yadav. Plaintiff has also got exhibited some documents, out of which exhibit 1 is an agreement dated 19/9/1994 purported to be executed by Mahabir Rajak as Gaya. If there is an agreement, my lord, it has to be signed by 2 parties, both the parties.
Not necessarily.
Well, but the evidence says she had tried and there is no signature.
No, evidence says that she has not signed.
Well,
There is no finding that she has signed.
well,
It does not bear the signature of the plaintiff. That is the finding of the court. That is the finding of the court that it does not bear the signature of the plaintiff.
well, in fact, PW3 says one of the witness to the crime.
Forget it. But the finding is that plaintiff has not signed it. The plaintiff has not signed it.
Whether I have read it, I will place it. But if there had been a evidence there, I don't know whether she has signed, the matter would have been something else.
No,
But
she has not signed it. There is a clear finding that there is no, she has not signed it.
But her own witness says she has signed.
Maybe. But the document
And
is
he is
there,
a
no?
witness to the document. He is a witness to the document. 84 to 99, 15 years rent was paid. There is no proof. There is no proof. The property was purchased long back. The rent receipt is given only of the year 2008. These are the things which prove that a vacant land was given to the defendant father and he had erected a
PW3
Today, my tongue becomes pursed. I will take permission to take some water.
Yes, sir. Fine.
अच्छा ठीक है
May I read my note for my lord's kind consideration? My lord, may I ask my learned friend to read it for my lord's?
Not ठीक.
PW3 साक्षी
संख्या 3 वादी की ओर से मैं लालधारी राम पिता श्री मोहन राम उम्र 63 वर्ष निवास स्थान रांची और सोलन। मैं वादी प्रतिवादी एवं विवादित मकान को जानता हूँ। विवादित मकान का मालिकन वादीगण एवं प्रतिवादी वादी का किराएदार है। प्रतिवादी के पिताजी महावीर रजक के वादी से विवादित मकान 60 रुपए मासिक किराए पर लिया था एवं बराबर किराया देते थे, जिसमें एवज में वादी हाथ चिट्ठा दिया करते थे। प्रतिवादी के पिताजी ने विवादित मकान किराए पर लेने के समय दिनांक 19/9/84 को एक किरायानामा भी किए थे। यही वह किरायानामा है जिसे प्रभु प्रसाद साहब ने महावीर रजक के कहने पर लिखा था, जिसे महावीर रजक ने मेरे समक्ष इकरारनामा पर पढ़कर समझकर अपना हस्ताक्षर बनाया था।
His specific statement is that Mahavir Rajak had put this signature.
Paraphrase says, उक्त इकरारनामा पर मैंने भी अपना हस्ताक्षर गवाह के रूप में किया है। मेरे अलावा प्रभु प्रसाद साहब, नागेश्वर प्रसाद, खलील खान, जगमोहन शर्मा एवं दोलन चौधरी ने भी गवाह के रूप में अपना हस्ताक्षर किए हैं। इकरारनामा मेरे सामने लिखा गया था एवं
इसमें भी किसी भी प्लेंटिफ का नाम नहीं।
It has not in the cross exam.
क्रॉस में कैसे होगा? क्रॉस से थोड़ी डिसाइड हो जाएगा। It is not his case while exhibiting this document. He has simply stated क्रॉस में अगर मान लीजिए बोल भी दिया है, it is not his case. He has deposed, he has given the name of the persons who had signed in the account.
My lord, may kindly allow us to place the cross examination.
Para 9 and 13।
Yes, I've seen para 9 and 13।
एग्रीमेंट लिखने के समय प्रमिला देवी मुझे बुलाकर ले गई थी। para 13 एग्रीमेंट में प्रमिला देवी का हस्ताक्षर था। Therefore the inconsistency in respect of Exhibit 1 is there. The
That shows it was a forged document. It has been prepared for the purpose of. It has been prepared for the purpose of making out the case that I was a monthly tenant since 1984, and there is not a cheat of Hath Chitta from 1984 to 1999. It is alleged that Hath Chitta was issued. Not a single document is proved.
The learned counsel for the parties are present. The appeal has been admitted for final hearing by the order dated 29/7/2021 on the following substantial question of law. The hearing of the case has commenced. Since the court time is over, court pose this case for further hearing tomorrow. साढ़े 10 बजे फर्स्ट केस पार्टनर है, फर्स्ट केस होगा। Let this matter be treated as part.